Well, I am mentioning for extension of interim order, my lord.
Hand over the slip. Extension of interim order, please hand over the slip.
Listed motion.
Lord.
Please wait, Mr. Kundu. Yes, listed motion, please hand over the slip.
Listed motion. Motion.
Please wait.
My lord, I
Please
think
hand over the slip.
1105 of the monthly is, my lord, some urgency, my lord, challenging the.
Please wait. Listed motions, inclusion, please hand over the slip. Upgradation, please hand over the slip mentioning the urgency.
My lord,
And if there is any opposite party has entered appearance, please serve notice, then mention. Which item is there?
oh, দুটো ছিল, sorry.
141? Monthly list. Monthly list. Wait, please wait. Yes.
Yes, monthly list, my lord, 1104, 1105, my lord, challenging the finding of the arbitrator that they are not functus officio, my lord. Award will be passed any day, my lord. There's some
Please mention the urgency. Hand over the slip.
grateful.
My lord, this is for correction of your law.
Correction. Please hand over the slip.
Lordship, the original will has been kept in the safe custody, and for that reason, we are not able to file a fresh application for probate. It's
Where it is kept?
it's kept in safe custody of district Barasat, district judge Barasat.
Yes. What is the order you are challenging?
We are challenging the order of the safe custody itself, because we filed an application for return of the claimant in our application for probate matter,
Yes.
which was heard and allowed.
You have applied under Order 7 Rule 10. That was heard.
That was however, the original copy is transferred
Transfer is there unless it is returned. How can it be returned? Please hand over the slip mentioning the
the
urgency.
same is not returned. I cannot file a fresh application for probate, or I cannot get it transferred to city civil court until and unless
Challenging that order or you are accepting that order?
that order.
Then if you are challenging that order, you succeed. So there will be no return of claim. How the will can be returned?
It's it's beyond the jurisdiction. The death of
Then you accept the order of return. I cannot understand your submissions. One way you are saying Order 7 Rule 11 allowed, you are challenging. Other way you are saying
Lordship,
no.
the order section Rule 11 was allowed, wherein the plaintiff was
Mentioning the urgency, I will consider.
Your Lord,
May I be permitted to mention item number 386 of the monthly list, lordship? In this matter,
What do you want?
I want upgradation, lordship.
Mention the urgency, hand over the slip.
Your Lordship, I'm seeking leave to file without the certified copy, Your
What
Lord.
is the urgency, madam?
Your Lordship, my physical possession will be taken of my secured asset, Your Lordship.
Against the order of
The learned DRT. The learned DRT upheld the order passed under section 14, granting physical possession of my secured property.
you file it, give the number, it will appear.
Your
May I be
Lordship, this is
permitted?
filing without the certified copy, Your Lordship.
You have the server copy.
Yes, Your Lordship.
Leave to file without the certified copy.
Your
with the
Lordship,
server.
may I be permitted to mention one matter?
Thereafter matter is listed application heading, but my filing application for extension of interim order, Lordship.
Extension of interim order, you have filed an application.
Lordship, file an application, Lordship. Lordship, kindly fix, otherwise, Lordship, the next date of trial court, Lordship, 18/7, 18/7, Lordship. Otherwise,
18th of July.
Lordship,
What is the item number?
item number 387.
387.
Lordship.
Come at 3 p.m. today, 387 tab.
Your Lordship, may I be permitted to mention one matter? Lordship? This is
The other side is there.
That's the other side, I'm not issued. Lordship,
You have solved.
are they already issued?
তাহলে ওটা এক্সটেনশনে কালকে দিয়ে দিন
May I be permitted to mention one matter? This is matter content application
hand over.
it already been issued.
Expedite disposal of the suit ballot of.
What do you want? Upgradation.
Yes, Lord, upgradation.
Upgradation or inclusion?
Upgradation.
Please hand over the slip mentioning the urgency.
May I be permitted to mention, my lord, on 26th June, my lord had passed an order, my lord. This was the order, my lord. A fraud has been played upon this court, my lord. The learned advocate for the opposite party neither has filed any wakalatnama, neither has given his name therein. But what has happened in this matter, I have challenged the genuinity.
What has been passed?
that the learned advocate on record of the petition is directed to serve a copy of the application upon the learned advocate for the opposite party on Monday. And it is, however, made clear that the pendency of the civil division application shall not preclude the learned work of tribunal from proceeding with the OA hearing in the meantime. Now, as this order was passed upon the prayer of the opposite party, my lord, the opposite party.
You mentioned, you mentioned it.
Yes,
Mr.
Lord.
Chatterjee.
Lord, one matter, my lord, has been disposed of by my lord. And my lord, these three matters are with respect to same premises, same parties, my lord, only the opposite party tenants are.
What was the impugned order?
My lord, impugned order, my lord, I have sought for due to the dilapidated condition of the house. My lord, I sought for an expeditious disposal of these four suits. My lord, in the same premises against the four tenants. Now, my lord, one has been disposed of looking at the condition. My lord, other three, my lord, are pending, my lord, has gone down in the list.
To be mentioned at the Yes, Mr. Mitro. Yes. Daily list or the monthly list? Yes. Please ask your junior to mention the urgency and
My lord, may I be permitted to mention a matter for upgradation, my lord? It's running as
please hand over the slip mentioning the
My lord,
urgency
item number 276, my lord.
of the
My-
daily list.
Of daily list, my lord. My section 34 application has been returned. And my lord, we've preferred an revision application that was admitted. Now, citing pendency of this, my lord, they are dealing with the property now.
Hand over the slip. Yes.
Kindly
Hello,
sum-
your lordship. To mention, my lord, item 618 of the combined month list, my lord, the matter is urgent because, my lord, the maintenance with regard to the area amount of maintenance is pending.
Please mention the urgency, hand over the slip.
With your lordship,
Immediate is there, Mr.
Here,
Chakraborty.
Mr. Devjit Mukherjee is
Have you served upon him?
Yes, sir.
my lord, I will serve in court.
Mention after serving.
Lordship, may I be
After service.
Lordship, may I be
What
permitted
is
to mention?
mention upgradation without service? No. Yes.
Lordship, may I be permitted to mention a matter for upgradation?
Please hand over the slip.
With your lordship, kind permission, may be permitted to.
All right, then hand over the
Your
slip.
Lordship, may I be permitted to mention a matter for inclusion? This was supposed to,
Hand over the slip. I have asked you to hand over the slip. Under what heading?
it was supposed to run under heading contested application.
Contested application দিয়ে দিন, ফেরত দিয়ে দিন। Contested application slip ফেরত দিয়ে দিন। Yes.
May I have your lordship's kind leave to pray for a innocuous leave before your lordships. But what has
Leave
happened?
to what?
Leave for my lord. What has happened is the certified copy which has been appended to the petition. My lord, inadvertently, two lines have been written, the phone numbers of the learned advocate at the back side of the certified copy. My lord, I was beseeching your lordships for a leave so that I may struck it off and have it filed.
Certified copy don't
At the
touch.
back, no, that is the reason, my lord. I am before your lordships for a leave. It is inadvertence of my client, my lord, which has happened. My lord, at the back side of the certified copy, the phone numbers of the learned advocate has been written.
All right,
But may I struck it off, my lord?
don't do anything now. Leave to file with that certified copy. ওটা করে দিন।
Grateful.
Leave to file with the certified copy.
Great.
My lord, may I?
So,
My certified copy as annexed to the, as appended to the civil division application.
so very great.
My lord, may I permitted to mention for inclusion of restoration application?
Hand over the slip.
My
my lord, may I mention a matter? CO 3182 of
What do you want?
my lord, on the last date, this honorable bench was directed that this matter will appear in July monthly list, but it didn't appear.
Under what heading?
My lord, I have to check, my lord.
Yes. Yes.
My lord, may I also mention?
Only urgency is, my lord, that is 14.
Then the urgency, hand over the slip.
My lord,
Date is the last chance.
Then the urgency, hand over the slip.
my lord, kindly keep this matter, my lord, CO number 2367 of 2025. Please to include the inclusion in the matter.
Under what heading?
My lord, it's already listed. Yes, last week, my lord.
Yes.
Upon hearing, you have I prayed for adjournment and
Adjournment, madam, please, you have to.
I know, my lord.
Adjournment
My
will
lord,
appear in due course.
Ma-
Madam, it was called on. If you have paid for adjournment, please wait for
my
conference.
lord, I have disposed this from my property, my lord.
Maybe you have paid for time. What can be done? Yes.
Item number 92.
Yes.
On my list.
On my list.
On my list, Lordship. In connection with that matter, petitioner number 1 already died during
What do you want?
I upheld an application, possibility appear as to be mentioned or application, any day.
For what?
Substitution, I have already, this is not simple
Substitution within time.
time.
So it has to be before the
Simple substitution. Petition number 2 and opposite party number 3 are already on record, and why it has to be substituted in place of petition number 1. Lordship, let it appear as to be mentioned or application by your lordship.
ওই আইটেমটা অ্যাপ্লিকেশনে yes
Item number 1402, considering the prolonged pendency of the execution case of the landlord, your lordship directed the matter immediately. Last week of June it appeared, your lordship directed to serve and to appear, my lord, in this month list, and my lord, apprised that if your lordship is of the opinion, my lord, I should mention the matter after publication of the list. My lord, it is item number 1402. Prolonged.
Mention that in the urgency and handover.
Upon notice,
Yes.
Lordship, this matter was filed in April, but never came up before your lordship for hearing. This is a new motion matter, lordship.
Under what heading?
Under under listed motion 10, lordship.
Yes.
186.
Yes.
for the second time I mentioned, for legal matter.
Enlistment. Under what heading?
To be mentioned.
Why to be mentioned?
For release, because Mr. Potter is appearing on the.
For release. এই ওটা আসছে না কেন দেখ? Yes.
My lord, 3182 in
Under what heading?
contested.
Contested, madam, it's not possible now.
My lord, may I be permitted to mention one matter for inclusion in the list? The matter is appearing under listed motion.
We are subject to the leave of the court. This is for the non-prosecution, and the second time, my lord, this I mentioned. Lordship,
Yes.
kindly be.
Under what heading?
It will be come under the heading of to be mentioned non-prosecution.
Non-prosecution. Non-prosecution আসছে না কেন দেখুন?
The second time.
Yes.
My lord, seeks to mention item number 325, my lord.
What do you want?
My lord, it is a listed motion, very short matter, my substitution
What do you want? Upgradation.
upgradation.
Please mention the urgency and over the slip.
Lordship, mentioning for upgradation. Lordship heard it and we fixed it for 6th May. Since then it is not appearing. It is now on number 197. The matter is very simple. Lordship was founded the perversity. It was halted at the end of the slip. No stay is there. That's how we are. There is no stay in the lower court order. Kindly upgrade.
In the monthly list of July in the under heading content.
Interstate not possible now. Yes.
New motion, never taken up.
New motion. Please.
With your lordship, kindly may I be permitted to mention, my lord, for virtual mode, my lord.
Yes, yes.
My lord, item number 548 of the month list of July, my lord. The expeditious, one of the matters, the expeditious disposal matter. My lord, in the Parashad court, the matter is.
Ask your the slip mentioning the urgency. Yes, call the list.
My lord, may I kindly be permitted to mention, my lord, this matter is running in the monthly list.
What do you want?
My lord,
Upgradation.
my lord, a date may be fixed for hearing.
Please mention the urgency.
Yes,
and
yes.
on the slip. Yes, call the list.
For the petition,
Yes.
my lord, as per the order passed by the Honorable Justice Vishwajit Basu, my lord, the mediation, my lord, Justice Vishwajit Basu has sent for the mediation. The mediation successfully held and
Mediation successful. Who is appearing for the other side?
The other side, we are already informed, my lord, but they are told that there is no more in the matter, my lord. I don't know, my lord. But my lord, the mediation successful and the money has been received by the, my lord, the wife. My lord, the receipt copy of the, my lord, the wife. A mediation order, my lord. Upon these terms of settlement.
There are 6 points.
Yes.
7 points.
7 points. And the money receipt is there, my lord.
All right. Ashun. You are for the petitioner?
Yes, my lord. I am for the petitioner husband, my lord.
এই এটা ভুলে গেছে order sheet. Order it was paid.
My lord, the order, my lord. My lord, the order dated, my lord, 18/9/2020.
By the order. Let's call the next matter.
My lord, I appear for the, my lord, petitioner, my lord.
Or the respondent.
Appearing,
Yes, Mr.
my lord, I am
Doctor.
appearing for the petition. Yes, my lord, lordship, this matter was mentioned by me because of the predicaments we are facing. 12th of June 2025, lordship had passed the order permitting, my lord, transfer of that, my lord, proceeding before the State Commission Asansol to this, and we were required to apply. Now, we had applied before the, my lord, principal bench. The issue which we are facing is, my lord, there is a portal, e-Jagriti portal, where, my lord, this has to be filed. Now, we have, my lord, mentioned the matter before the president, before the, my lord, honorable chairman of the, my lord, State Commission principal bench, and showed this order of your lordship. Thereafter also, my lord, we could not, my lord, register our, my lord, application because they say it's a...
Yes, what are
my
they
lord,
saying?
My lord, they are saying it has to be done first in the e-portal, and my lord, that application is not being registered due to some technical difficulty. We tried to contact...
So, Doctor, what is the technical difficulty?
My lord, the technical difficulty is, my
Mr.
lord,
Doctor,
error messages are popping up, my lord. We cannot, my lord, there are some error messages which are popping up, which is disallowing the application to be filed. So, in the circumstances, I was only praying this, my lord.
Been served with a copy of application. We were in the dark. We didn't know that any application has been attempted to be filed.
Mr. Doctor,
my lord, once it is filed, I am not in a position to move it before I give notice to Mr. Kaur's client. I will not do that.
But Mr. Doctor, why are you not serving an advance copy to them?
I can do that, my lord, but that's not the problem, my lord.
Mr. Doctor, it can be solved if you give them a copy. Mr. Kaur says they will give consent for physical filing also.
Let him mention.
My lord, that is also not possible, my lord. My lord, kindly hears me, my lord. Kindly hears me. That is also not possible. We tried mentioning it before the bench. Physical applications are not being taken, my lord.
Mr. Doctor, do one thing. There, Mr. Kaur's representative will also be there. So after hearing, if it can be sorted out, it can be seen. Give them a copy.
I understand. Lordship
Yes.
may kindly make an observation to this effect. I will again persuade the bench, my lord. I'll give him a notice.
Mr. Doctor, do one thing. Serve a copy upon the learned advocate on record of Mr. Kaur. So, and you tell him, serving a notice when he will be mentioning, I'm adjourning, I'm directing this matter to appear under the same heading. After, tell me when mentioning, I'm keeping it after that.
But I'll try the mentioning next week. Lordship keeps it on 21st.
So, it will be trying in the next week. So, I'm keeping on 22nd of July.
And let them also indicate what are disputes or what are the defects which that is being pointed out. At least we can.
Mr. Doctor, do one thing. Why can you not communicate Mr. Kaur what are the defects so that they can also cooperate with you?
Absolutely, no problem.
My lord, my lord, please appreciate my problem, my lord. The difficulty is not from the opposite party. The difficulty is from the department which says that we cannot do this.
Mr. Doctor, Mr. Kaur also appreciated that. I am also appreciating that. But if both of the parties go and approach, they are also giving consent, something can be done before the president.
I will do that, my lord, and I'll have a word personally with Mr. Kaur. Please make one line observation which will help us, my lord, mentioning.
Mr. Doctor, this matter was directed to appear under the heading to be mentioned upon being mentioned by Mr. Dotto Learned Advocate appearing for the petitioner. First up, Mr. Kaur Learned Senior Advocate represents the opposite. Mr. Dotto submits that pursuant to the order dated 12th of June 2025, the petitioner made an attempt to file the
transfer application.
To file the transfer application before the principal bench of the State Commission.
Yes, my lord, State Commission.
Principal bench of the State Commission, but the same could not be done as attempted to file the same through online mode, but this the transfer application before the State Commission through the e-Jagriti portal, but such application could not be filed as the system indicated certain technical
error messages.
The system indicated certain error messages. First up, paragraph.
We mentioned also for waiver of e-filing before the my lord, honorable president.
Paragraph, Mr. Doctor further submits that he also mentioned this matter before the president of the state commission to allow the petitioner to file the same physically. Paragraph. Mr. Kaur Lanet, senior advocate appearing for the opposite party, submits that the opposite parties are not aware of any such attempt being made by the petitioner. He submits that no advance copy of such application has been served upon the opposite party till date. First up, Mr. Kaur suggests that if
and they have not been given any notice of mentioning either.
Mr. Kaur suggests that if an advance copy of such application is served upon the learned advocate on record of the opposite party and the learned advocate on record of the petitioner intimates the learned advocate on record of the opposite party about the date when the petitioner will be mentioning this matter before the president of the state commission, the opposite parties will be presented. Full stop. Paragraph. Since it has been submitted that there are certain difficulties in filing the certain technical difficulties in filing the transfer application through online mode. The President State West Bengal State Consumer Dispute Redressal Commission is requested to look into this matter and sort out the problem so that the application can be decided, can be heard out and decided on its own merit.
By waiving, my lord, by waiving the requirement of e-filing, kindly puts that, my lord,
that is why to allow physical, but that is the president can, if the Mr. Doctor, if the technical problems can be sorted out, then you can file online. President will be there.
My instructions are the president said that I don't have power to waive unless lordship provides that in the order he won't.
Something be done. So thereafter, full stop. Paragraph as suggested by honored advocates for the respective parties. List this matter under the same heading on July 22, 2025.
Very grateful, my lord.
Mr. Kaur also see that it can be done. If you give consent to this physical filing.
Of course, blood. So far as filing is concerned, there is no difficulty. We can contest the main matter on merits, but then filing is concerned.
This procedural part that can be waived.
Handmaid of justice. Well, always it can be. Blood.
I do not know why.
I also don't know. But if any notice was served, we would have definitely represented ourselves there.
Yes, there's some problems because this online mode. When everything is through online mode, you have to file through that. Certain uncommon things that the system will not accept.
System doesn't accept even if there is a slight mistake here and there. I mean, there is no difficulty with regard to that. I wholly.
If the mistake that is being indicated to them, they can rectify them. It's no problem.
Absolutely.
So I think someone must be there in the filing section or somewhere there.
If the president calls one of them and ascertains, and I
can be sorted out.
I think your lordship's observation that he should sort out, that should suffice. I'll ask my advocate on record to go and assist.
And if there is I do not know the procedures. If you can see the procedures of online,
I'll check.
Please check up, Mr. Doctor. You also check up. And sit with Mr. Kaur with regard to this. It's not on other things with regard to these technical issues. If it can be sorted out, procedural part.
Check the rules.
I think there cannot be any difficulty. There may be a contest with regard to the main matter. There should not be any problem with regard to
other matters which are being filed. So, I'll individually inquire also.
Yes.
What should be the setup.
Thank you.
Grateful, my lord.
Call the next matter.
Lord, before I start this matter, my lord, with
why it is for orders.
Lord, your lordship wanted us to take instructions about. I'll tell your lordship this. Lord, yesterday's your lordship's query on Tika tendency and
yes, you have got that.
Lord, Justice Tandon's judgment is a little different. there is a judgment of Justice Jyotirmoy Bhattacharya's division bench which says civil court doesn't have the power. And Justice Tandon and Bharatiya eviction. And Justice Tandon
was hearing this issue.
Lordship was hearing, my lord. I will check again, my lord. I haven't found the entire thing. Justice Tandon has a single bench judgment which says that civil court's powers have to be taken away expressly. And in a suit for declaration, with respect to, my lord, payment of money or something, that was, my lord, said to be not under section 9. So therefore, my lord, the suit was maintained.
But not a
eviction suit.
Not an eviction suit.
Not an eviction suit. So what happened after Justice Bhattacharya's judgment, my lord, that's a division bench judgment.
So division bench is, single bench is also binding if there is no contrary. A division bench
is
that is on eviction.
On eviction.
You have got that judgment.
That judgment, I'll send it to you.
Please see whether there is anything.
It's a reported decision, my lord. If I'm not mistaken, it's 2000.
Please, if you can get a copy of that.
I'll do. I'll just tell your lordship, my lord, the citation.
Yes. Yes.
Just give me a second, my lord. I'll just tell you. 16.3 CHN, page 1.
Yes.
2016 3 CHN, page 1.
2016 3 CHN, page 1.
1.
I think Justice Siddhartha Chattopadhyay's judgment is also in 2016.
Yes, my lord. It was Krishna Shaw.
The Costatle is Krishna Shaw.
Krishna Shaw.
SHAW.
SHAW. SHAW. This is Justice Jyotirmoy Bhattacharya's judgment on, my lord, eviction.
Considering section 7 also.
Considering section 7, considering section 9.
9 of
tenancy. I'll just.
And section 7 of premises tenancy, section 6 of Premises Tenancy Act.
That was not considered.
That was the issue, Mr.
Not considered. Not considered.
Then what can be done?
Lordship considers, my lord, section 8.3 and section 2.2. Yes, 8.3 and 2.2.
No, Mr. Chatterjee, if other provisions are considered, it's not because the controller forum has been fixed.
That part that we thought was correct yesterday, my lord, was that the
section 7 whether can be, because that was the argument which was being at.
Well, I'm sure there is one more judgment which I can't find out. I couldn't find out last night. I will use, well, probably tomorrow and day after I'm in.
You can take the weekend.
The weekend, my lord, I'll try and, my lord,
yes.
Lord, in this matter,
if you find time, if you can make a compilation of those
I'll do that.
those judgments on that point.
Your lordship is wanted, my lord, I'll definitely. My lord,
because that is the point which may crop up.
It will, and if it's not decided, my lord, then it requires decision.
So now it's a division judgment, whether it's considered, not considered, binding.
Binding, and then if there is nothing contrary from the division bench,
yes,
even your lordship cannot even
refer.
Cannot even, if your lordship says per incuriam or sub silentio, or, my lord, that point will not argue, then your lordship may refer it. But not otherwise. If a provision is not considered and a judgment is passed, considered and passed is one thing. Not considered and passed, then your lordship can, my lord, say that this can fall under per incuriam and send it to the larger bench.
But there is no other difficulty excepting section 7 compliance.
Absolutely. Not just 7, my lord, the paraphernalia under it.
Yes,
so
section 7,
money,
everything.
Where will the money be kept? Everything has to be, below.
Otherwise, there is no difficulty. Absolutely. So it's only one forum being replaced by the other one.
Your lordship would also have to consider the judgment where the controller was given the right of eviction, my lord, in the new Act, 97 Act. And then it was, my lord, directed to be said to be ultra virus because of this. Section 7.
Then, Mr. Chatterjee, the provisions are to be challenged. That I cannot do it here.
I completely bow down.
That I cannot do it here.
Completely bow down. It depends on the other side who comes. in the matter in hand before your lordship. It will depend on the other side who comes before your lordship and what argument he makes on this point. If he concedes, my lord, your lordship need not trouble my lord's self. But if your lordship wants to lay down the law, then a lot of things have to be considered. But I'm pretty sure, my lord, Justice Tandon and the division bench passed the judgment.
Division bench?
Yes, yes. Pretty
Justice
sure.
Tandon was hearing in the single bench.
Single
That
bench
was
I
not
have.
aware.
Your lordship appeared in one matter and lost to Mr. Rai Chaudhary.
Yes.
I have seen that. But that, my lord, it was not a suit for eviction.
No,
That was a declaratory suit.
No, in this matter, in a dispute of this, I was also appearing, but thereafter.
Your lordship got elevated or Justice Tandon lost side or whatever, my lord. But I am
Final hearing did not take place.
Look, I am quite sure there was a judgment. If for some reason it doesn't, Miller, I probably didn't write it down or something. Miller, I'll use the weekend and I'll assist your lordship on the next week.
Because this is an issue and
it
I
is
may
an
require your assistance
It is
then, if this is to be decided. If this issue is to be decided.
I'll give your lordship the judgment. For that, Mr. Rai is there, your lordship.
All of it, Mr. Chatterjee.
I'll assist
That
you.
is an issue that has.
I will assist your lordship. Lord, in this matter,
yes.
Lord, your lordship.
What happened? Why it is for orders?
Lord, this was a section 10 matter where I said, Lord, that I will take instructions if all
probate and partition.
Yes, yes. So here there are 3 suits. There is already an order, Lord, where there are 2 suits were directed to be heard together.
Which 2 suits?
One suit is for declaration, which he has prayed for declaration.
Of what?
Of that he is an adopted son.
All right.
One is a partition suit. So everywhere, Milord, the issues would be the same on title.
So that declaration and partition
are being heard together.
By an order.
By an order of this honorable court.
All right. So now the only thing is that probate. What is to be done with the probate?
Yes.
Yes. Now what is your instruction?
Kindly does it. I have no problems. Does it. Same set of evidence. Of course, the probate evidence will be a little bit different.
A different thing altogether, but
for sake of convenience,
it will have an effect. Otherwise, Mr. Chatterjee, there are 2 lines of decisions. One is that all are to be heard together. Other is that partition suit and this can proceed independently.
And the probate also.
But no premier degree will not be passed up to evidence.
They have not prayed for. So I'm not getting into that. They have not prayed for that.
These are the 2 alternatives.
Yeah,
that can both these can be allowed to proceed. Partition suit will proceed up to the stage of that evidence completion just before the passing of the
proceeded. Probate court Milord is now taking evidence.
And the partition suit
has proceeded. Milord, partition suit.
Probate court, Milord, I have 2 sets of judgments. Milord, if your lordship kindly have a look too.
No, these are the 2 sets. You have the 3rd set.
Yes, Milord, third one is there. My lord,
third set.
Milord, the 3rd one is Milord.
These are the 2 sets of judgments.
My lord, Justice
and in one
singly, Milord. My lord, Justice Kalidas Mukherjee, as his lordship then was, Milord, sitting singly, Milord, passed an order that Milord, even if Milord, the partition suit is a prior suit, Milord, the probate suit is completely different from partition suit. And Milord, section 10, Milord, need not Milord, be applied here.
Mr. Chakraborty, may not be section 10, 151.
Yes.
So don't go into that. 10 is one thing. Subsequent suit, issues identical, parties same, has to be stayed. Subsequent suit, if the issues are. There may be cases where strictly section 10 may not apply. So
I have, Milord, I have 2 judgments to cite. Lordship can consider these 2 judgments, Milord. These 2 judgments, Milord, one passed by Malad Mr. Shubhakamal Mukherjee, Milord, reported in WBLR, and second one is Malad Mr. Kalidas Mukherjee.
Shubhakamal Mukherjee considered those Supreme Court, I think of 2004.
Yes, Milord, Lordship
kindly appeared in that matter.
Lordship kindly sees, Milord, it is reported in Milord.
Who appeared in that matter?
2005, Milord, WBLR, page 713.
I think 2004 Supreme Court was considered.
Milord, I'll just check.
2004 SCC.
What has been held here? Milord, partition suit, Milord, should be Milord proceeded with. It should not, Milord.
Up to what stage?
Milord, the stage has not been mentioned. Lordship kindly sees paragraph 13 onwards. Milord, the relevant paragraph is 16, 17, and 18.
Yes, paragraph 18, Mr. Chakraborty.
Yes, Milord. Lordship kindly sees
the application such and such, read with such and such is dismissed. The learned trial judge is directed, I hope and trust that they will be able to pass. Oh no, I think, where is that issue? It has been,
Paragraph 14 onwards, if your lordship kindly sees, my lord. এটা আমি এসএসসি অনলাইনে পেলাম থেকে পেলাম জুরিস থেকে
no, Mr. What was the, this was, I think with regard to the who will represent.
It's the other way around.
Who will represent that person in the party?
that question was
That's
there. That was the question there.
Yes, so it's not on that. Chakravarti will get judgment
Now,
of
Lordship-
Justice Mukherjee on
Yes,
this
my lord.
issue
That judgment, my lord, just I'll rely, my lord. Lordship kindly see this, my lord.
Mr. Chatterjee, where are those Supreme Court judgments?
I thought
2005,
agreed,
there are
my lord. It was agreed between us that your lordship would, my lord, just give your lordship the.
I found it otherwise, my lord. My lord, it is.
That's why I did not.
Chakravarti now wants to,
Then if he
argue.
wants to, then I'll have to get those judgments. But this
Lordship
case
kindly
doesn't
sees, my
apply
lord,
at all.
paragraph 2 and paragraph 4 of my lord, Mr.
I have also,
Kali-
I think I have also delivered a recently a judgment on
My lord, 2 Supreme Court judgments also, my lord, I'll be
What's that?
relying on.
No. My lord, I thought because I didn't think there would be an argument. So I thought, my lord,
because
what was
Mr.
agreed,
Chatterjee,
I'll
I
just
tell
give your
you
lordship the
frankly, because
facts.
these are the two views which I had in my mind. The Chakravarti now says there is
No,
also a
it's
third
not-
option.
It's not a different view.
No, this is not a different
No,
view.
No, my lord,
This,
his
this
judgment,
is who will
lordship.
represent,
Absolutely.
who will
And
represent,
on the contrary, says the partition suit will go on.
yes.
So that's
partition
exactly what I'm
suit
saying.
will go on. The issue was, it has to be stayed till the probate because who can represent that person? Whether
Absolutely.
the executors or the
Absolutely.
legal heirs.
The High Court says that the partition suit will go on and will not be stayed. Because
So,
this was
issue
stayed.
was
my lord.
different. Issue was not that.
Now, lordship kindly have a look through, my lord, this judgment, my lord. Lordship kindly sees paragraph 4.
Here, my lord, the trial court, my lord, stayed the suit because stayed the partition suit. The High Court says you can't. Sees, my lord, paragraph 8. 12.
Mr. Chakravarti, this paragraph 4 is contrary to 2005.
Yes, my lord. My lord,
Yes, you
my
have
lord,
got those.
I have got those.
Two decisions, earlier volume,
But my
is
lord,
the subsequent
Two
decision,
decisions I have. My lord, lordship
subsequent
kindly
volume,
sees.
the earlier decision.
But my lord, my lord, the set of facts, my lord,
One
is
is by
different.
Justice Pal. One is by Justice Pal. I do not recollect who is the author of the other one. So, short judgment, 2-3 paragraphs judgment.
ওটা বলছো দাদা, দুটোই আছে আমাদের। তোমার কাছে জেনেছিস?
2005.
My lord, 2005, volume 2, 505 is one.
Yes.
And my lord, the second one.
I think in volume 6 or so.
No, my lord, the same volume. My lord, the second is.
Hegde.
One judgment he will be finding it's
One is
clubbing.
503, another is 605.
Transferred to that.
Exactly what I'm trying to say.
Is it Justice Pal's? No.
No.
The other one is Justice Pal, where it has been said that.
Three judges bench.
So, lordship kindly
Yes, one is 3 judges bench.
দাদা একটা দিও আমাকে।
Exactly what I'm trying
These
to say.
two judgments, but my lord, kindly see the facts of the case.
Then Mr. Chakravarti, Mr. Chatterjee wants to consider this.
Lordship kindly sees, if your lordship kindly have a look to
my
the
favor,
50. No, it is really.
Yes, this is the judgment.
But the fact
Yes,
is
this was the judgment which was 2005-12.
Absolutely.
Be that as it may, the will
lordship
will have
kindly sees 503.
the will have a direct impact on the suit. So this is contrary, Mr. Chakravarti, Justice Mukherjee's judgment. which you
Your
have
lordship
placed.
is looking
It's
into
not-
my lord 503, my lord, or 505.
505.
505. Now, lordship kindly sees.
503 has only said clubbing and other things.
Lordship kindly
nothing.
sees 503, my lord, 505, the my lord, set of facts.
Without expressing any opinion on the merits of the controversy, we request to convenient to dispose of the probate proceedings along with the civil suit.
This is, my lord, completely, my lord, in exercise of, my lord, the power under, my lord, Article 140.
151.
No.
Now, lordship kindly sees, my lord, the
Chakravarti, please, what is the reasoning? Reasoning is because the decision in the probate proceedings on the question of proof of the will have a direct impact in the suit. Because, Mr. Chakravarti, what is being done? Two things. One is what will happen if the probate is allowed or the probate is dismissed. So if the probate is allowed, the persons who are the beneficiaries under the will, they will have a share. Because if there is no dispute with regard to the share of the testator,
There was no problem.
so there is no difficulty. So it's only who will get that. So during the pendency, what can be done as in the other judgment, executor has a right to contest or to proceed with.
Judgment, yes.
Even preliminary degree also can be passed. There is a question of shares who will be getting.
There can be two preliminary degrees in a partition.
That is right. And the other way is, yes, everything done, stall the preliminary degree for the moment. Let's see what happens. Probate can be decided.
So the problem is
there will be no difficulties passing one another again.
Exactly. That to obviate that, Lord, and there is no further delay because my partition suit is of 2001. There is no further delay, my lord. Both the suits are really, my lord, ripe and evidence is on.
Both can be clubbed. Mr. Chakravarti, both can be clubbed, can proceed. It's one way. Or if you don't want that, this can proceed. Partition suit will also proceed. But just before
that will be very difficult for me, my lord, because my suit will then, after a point of time, be stayed.
Last 3 days, my lord, I am told, my lord, they are praying for
what is the difficulty if both are decided together? What is the difficulty?
My lord, the difficulty is, my lord, only one aspect, my lord. It is pending before the learned additional district judge.
25th, my lord said.
Probate proceeding, district delegate, and this is pending before the learned senior division.
Exactly what has been done.
But Mr. Chatterjee, one difficulty. I do not have section 24. I do not have section 24.
That's inherent. Inherent with your lordship.
Mr. Chatterjee, when the
Justice Shubhra Kamal Mukherjee's judgment again, exercising section 24 in article 227, transfers the suit.
Mr. Chatterjee, when
Even the division bench.
Mr. Chatterjee, that may not be a problem. I can request the district judge to place it. So that is a different way.
Sure, your lordship. Can we seize takes up the revision application? Takes up the revision application and sees the division bench judgment in our suit. Turns to yes, turns to 17. Thank you.
No, Mr. Chatterjee, this is the division bench.
Division bench doesn't have the powers, my lord, under 24. If it's in the strictest sense, but this is done in our suit.
Mr. Chatterjee, we in a larger bench have said in a larger.
My lord, if there is, I'm sorry, I should never say no. I bow down to your lordship. Larger bench doesn't have something which your lordship doesn't have. Section 24, my lord, is inherent.
Section 24.
Your lordship directs the district judge to transfer it.
Inherent maybe, but
for the sake of convenience.
When the Honorable Chief Justice have given.
No. Under 151, my lord, it is a power which is saved before your lordship. Your lordship has the powers under 151 as well.
Go that far.
So
let us not go that far.
I bow down.
My lord may pass an order
by other means. So,
my lord may pass an order, my lord, both may run concurrently, and at one stage, one should stop.
No,
that is, my lord.
That is
both the same. Runs analogously, there is no difficulty.
No difficulty.
Both will be.
All three will go together.
Chakravarti, both the same runs analogously. One cannot be decided apart from the other. What are you submitting?
No. My lord, I am not saying that. My lord, I'm
not saying one after the other. I am saying together. Together one cannot be.
Together it cannot be. My lord, it is completely, my lord, together it cannot be.
Analogous hearing.
Saying, my lord, lordship may kindly considers, my lord, if your lordship kindly passes an order that the partition suit will run as its, my lord, own motion, and my lord, this will also run. But my lord, the final, my lord, stage, my lord, one has to stop.
Why?
Mr. Chakravarti, why are you interested in stalling one proceeding?
Exactly, 2001.
Why are you interested in both the proceed at the same time? I think you don't want the partition suit to be.
These are two different stages.
Maybe. What are the two different stages?
My lord, partition suit
is going on.
My lord,
what are the two different
only,
stages?
my lord, issues have been framed. My lord, I am told.
That can be expedited. If the analogous hearing, Mr. Chatterjee's suit cannot proceed further. So your suit will be
lordship kindly
suit will be expedited.
Yes, my lord, lordship kindly passes a
Mr. Chatterjee, are you aware of
not
both
preferring-
both the suits?
Yes, yes, evidence is on.
No, my lord, in my suit, my lord, framing of issues. Lordship, can you see the last
What is the
order?
next date
That's
fix?
evidence.
When the issues were framed, that's the next date fix.
Whenever it is, my lord, the next date, whenever it is, from whatever stage, it will proceed together.
My lord,
I don't
it is,
think there should be
my lord,
any
at
problem.
best, my lord, it is, my lord, the stage of, my lord, suit, my lord, so issues have been framed. That is, my lord,
Always at the same
Ah,
stage.
same
but, my lord, evidence not state.
The Chakraborty is very difficult in two suits at the same stage. Some will be only filing of the affidavit in chief, other may be just
Then Lordship kindly, my lord, kindly, my lord, makes it
technical
clear, my lord, they will not prefer any adjournment because they have
I will-
not adjournment. Three occasions.
I will restrain both of you from praying for adjournment.
No, we are not praying. We are not praying.
Restrain both of you.
Absolutely.
And where is the other suit? Where is the other order?
There, annex.
It's here, annex.
Yes, yes. That's the page 17, my lord. 17.
Another suit.
Yes, my lord.
Mr. Chatterjee, this is from what?
One
This
is for
appeal was from
partition.
what?
One is for partition.
No, this is the why division bench? Oh, FMA injunction.
Injunction.
My lord,
Injunction, so
There are three suits: partition suit, a suit for declaration that he is the
which
adopted
filed by
son,
whom?
Partition
Declaration filed by him.
declaration by him, probate by him.
You have the plaints.
Lord, I tell your lordship, my lord, declaration filed by my mother. My lord, mother
If
died.
you have the plaint or anything, I have to record that who has filed.
Nothing has been annexed here.
I bow
You
down.
are aware of the facts.
Yes, yes.
All right.
My lord, no, my lord. The declaration suit filed by mother. My lord, I tell your lordship, my lord, the facts of the case.
এটা দিন তো একটা কাগজ দিন তো।
No, no, no. তুমি দেখো না। Come to it.
Declaration, what is the number of the declaration?
তোর suit ওটা।
No, no, it is not my suit. I'm the defendant.
Dispute. What is the factual dispute?
No, there is no factual.
My lord, probably my learned senior is properly, my lord, posted with the facts. My lord, partition suit by, my lord, my mother. My lord, I am the adopted son. My lord, 3 sons were there. 2 sons died in infancy, and my lord, 1 son is missing. So, my lord, I was adopted, my lord, during the lifetime of my mother.
Dispute whether he is adopted or not.
Let me.
That is the second
Then, my lord,
he is filed.
What is the number of the partition suit? That is the earlier suit. The partition suit is
10 of
the
2001.
earliest.
Yes.
Yes, yes.
10 of 2001.
10 of 2001.
One.
Here, who is the plaintiff?
We are the plaintiff.
Please give the name, first name.
Rajkumari Devi
alias
Sharma.
Rajkumari Sharma.
Rajkumari Devi Sharma.
Rajkumari
Devi Sharma.
Devi Sharma
Yes.
is the plaintiff.
He is the plaintiff. Then your lordship will find that the suit for
So this is the
declaration.
partition suit.
Yes.
My lord, the partition suit as of now, my lord, they have not taken steps even, my lord, for, my lord, striking of, my lord, or substitution of, my lord, defendant number 1.
Be done. There is no problem.
Uh,
Then below there is title suit number 190 of 2000.
No, no, 190 is neither here nor there. My lord, 190 is my suit. My lord, they are.
I want to know this
Yeah,
suit,
Ashton,
Mr.
what is wrong
Chakraborty.
with you?
না না তুমি ওটাকে ক্লাব করছো কেন?
Club করা
It has been
আছে।
clubbed all together.
What are you saying?
17. It is
Mr.
not.
Chakraborty, it seems you are not posted with the facts.
No, page 17, my learned senior is looking. Lord,
Yes.
clearly sees.
In a first miscellaneous appeal, page 17, we are informed that another suit for declaration by the defendant number 2, seeking declaration.
This, my lord, I have to take
Already
instruction
matured
already
informed.
disposed of or not. My lord, 195.
Together.
সেই সময় ছিল দাদা এটা দেখো কোন ইয়ার?
It's the heart of common code.
No, my lord, I do not know what is the stage of this suit. My lord, I need to take instruction.
Mr. Chakraborty, you may not know this suit. These two suits, your suit for declaration has been clubbed with the suit for partition.
At that juncture, it was clubbed.
তাহলে
Then, Mr. Chatterjee, please consult the facts. Please come to our.
my suit is pending.
Kindly sees the date of the order.
It is the suit is pending.
Let him take instructions. Let him. He wants one more conference.
Hey, your
What is the
lordship, kindly
difficulty?
record this submission. My lord, I do not have.
Face-
Sir, if he, my lord, says so, my lord, this is of 2005, my lord, I find this is of 2016.
Chakraborty, if this partition and the declaration suits have been clubbed together, Can one suit be decided prior to
What
the
has
other?
happened, Milord, I tell you, Lordship. Milord, I have been subsequently arraigned as a party defendant in the partition suit. Initially, I was there. Initially, I was there. Milord, I have been arraigned as a party defendant here, Milord, in the partition suit.
So according to you that your suit has been decreed?
No, not according to me, Milord. I have to take instruction whether it has been decreed or not. Otherwise, I would not have not added as a party respondent here.
Actually looks to Milord, Mr. Chakravarti is becoming a little.
But
This is the impugned order. The Milord,
Milord,
there
if
are
I have
three
been
suits.
added as a party defendant, Milord,
Mr. Chakravarti, there may be, because one thing, it may happen that there are other heirs of that deceased party and you are the adopted son.
no other heir, Lordship.
According to you, there are no other heirs.
Only
You are the
daughter and me.
adopted son. According to Mr. Chatterjee's client, there are other heirs.
He is no one.
There are other heirs, you are no one.
Milord, the
Might
person,
be the other heirs are parties and you have also been
the
allowed to
person
be.
died, Milord, 3 sons, 1 daughter.
Be sure, Mr.
Not
Chatterjee,
even,
please.
I am very sure, Milord, even if
He
the
has-
Lordship looks to the impugned order, 2 suits were clubbed together, the partition suit
I've
and the
seen
suit
that.
for declaration.
I've seen that now.
I sought for stay, Milord, of the probate proceeding till my partition suit is disposed of. I am saying the partition.
Anyways, Milord, Lordship kindly records and dispose it of. Milord, if my learned senior knows, Milord, I do not have the.
হয় কখন আমি
দাদা আমার কাছে নেই আমি
Yes.
বলতে পারবো।
Suit number, what is the suit for partition? Title suit number? No. Partition, what is the suit?
190 stage আমি
Declaration.
যাই না দাদা। 190 stage আমি যাই না আমি বলতে পারবো। Milord, declaration number is Milord, Lordship kindly
10 of 2001.
10 of 2001.
10 of 2001 is the partition suit.
Partition suit.
Declaration.
Declaration is 190 of 2000.
190 of
So this is the
2000.
first one.
No, no.
That is declaration, that is the adopted son.
Yes, yes. These were being heard together after the division.
What is the name of that plaintiff?
Bajrang.
Bajrang, Milord, your Lordship kindly sees Bajrang Lal Sharma.
Bajrang Lal Sharma.
Bajrang Lal Sharma.
My client.
Yes. And Milord, the
Adopted son.
adopted son. Alleged. And then Milord,
Yes,
he's-
but for declaration, that is the
yes,
adopted
yes,
son.
yes. And then the
Now,
section
now
10
the probate.
now the probate.
Probate is by Mr. Chakraborty's client.
Chakravarti's client.
Yes, what is the probate contentious cause?
OSWP, yes. OSWP case number 1 of
Yes.
21.
Yes,
OSWP,
what is that?
Will case.
original side, original suit, will probate case.
OSWPC.
WP case number
WP
Will and probate case.
case number
1 of 21, and there is a slash of 26 of 19. এটা কি রে number আছে?
This is the probate suit.
আচ্ছা 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 না 26 of 19 was when Milord he filed it. When
Now it is
became
1 of
contentious,
2021.
All right. So probate suit, will of
A Sharma, Sabitri Devi Sharma.
will of Savitri Devi Sharma. Propounder
Is him.
Bajrang Lal Shaw.
Yes.
He is the executor. Claims to be the executor.
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 Yes. So now let me take me to the impugned order.
Yes. Impugned order says, Milord, that since the issue
Impugned order, who filed the application for stay?
I filed the application for stay
In the probate suit.
in the probate suit saying that you please stay it till my partition suit is disposed of. I did not really make that submission before your lordship. The best available thing, Milord, for
That has
all of
been
us,
rejected on what ground? Section
saying that the issues are different.
Not different.
Issues are different. That is the only ground.
That's the only ground.
Ashun. Next.
My lord, I am appearing for the petitioner, my lord. On the earlier occasion, your lordship directed to submit affidavit of service, my lord. Service was effected on 5th.
Service effected?
Yes, service effected.
Do you have a resolution, no adverse order today? Then please come tomorrow. Because if you have
The
served,
difficulty is that, my lord, the interim order which your lordship pleased to pass in favor of the petitioner expired, or it has already been expired in the end
you
of
did not mention earlier. So if you
Yes.
could have mentioned
Yeah,
prior to expiring, all matters have been extended.
Yes.
So you mentioned after this, one day nothing will happen. 8 days are already over. One day nothing will happen. Because there is a resolution, otherwise I could have.
5 I appears for the opposite party number 1.
Petitioner is not here.
This is a very unfortunate matter. Lord, I lodged a caveat, but an interim order has been passed. Lord, on 5th of December 2024, the caveat has been lost. Lord, no service has been effected. Lord, I seen from the record that the caveat was also tagged.
Where is the learned advocate for the petitioner? Where is the learned advocate for the petitioner?
Present.
It has been submitted by the learned
My lord, Mr. Shubhendu Bandyopadhyay is for the petitioner, my lord. He requested me that may not be taken up tomorrow, my lord, for this disruption, my lord.
You are his junior?
Yes, my lord, but I am not recorded advocate, my lord, in this matter.
You are his chamber junior?
Yes.
You are his chamber junior?
No, I am not his chamber junior, my lord.
You are not his chamber junior? Not today.
Much obliged.
My lord, I appear on behalf of the plaintiff decree holder. This is a suit for eviction which was decreed in 2012. Thereafter, a title execution case was filed by us in 2016. The defendant thereafter filed a section 47 application under CPC for on the ground that this decree cannot be executed without specific description in comparison with the suit property.
Yes, this case has been fixed for hearing. Now what do you want?
Title execution case has been stayed, my lord, and there is a
I am expediting the miscellaneous case. I am directing the. Have you entered appearance in the miscellaneous case?
Yes.
You have filed your written objection.
Yes.
So I am directing the miscellaneous case to be disposed of. This application under Article 227 of the
Lord, in item number 8, the learned advocate on record is ill. He has instructed me to take an adjournment for a week, my lord. Mr. Shivaji Mitra.
Not today.
Wait, my lord.
Yes, call the next matter. Yes. Not today. Coming after 5 minutes.
Lordship, in item number 10, I appear for the petition.
Yes.
The husband respondent, Lordship, challenges an order passed under section 36, whereby he has been directed to pay 25,000 as alimony pendency light along with rupees 15,000 as litigation cost. Lordship, the matrimonial suit for dissolution at the instance of the wife, husband filed a counterclaim, Lordship, for restitution of conjugal rights. If Lordship kindly takes up the impugned order, that is of the 18th of February 2025, Lordship will kindly pardon, that has been marked. Page number is 126. If Lordship kindly takes up.
Yes.
Lordship, on page 126, Lordship, the last paragraph.
I have the certified copy, please, which is the
certified copy?
126.
Lordship, of my petition, Lordship, 126 has been marked. Lordship kindly takes up the certified copy, the last paragraph of the first page.
Last paragraph of the first page, yes.
18th of February 2025.
Yes, yes.
Lordship, the wife had claimed alimony pendently of 80,000 rupees along with litigation cost of 1 lakh a month. Lordship, court, Lordship kindly sees the finding of the court. There is no prima facie, the last paragraph I am placing.
Yes.
There is no prima facie document on behalf of the petitioner wife to substantiate the income of the respondent husband. But the respondent admitted about his job in a IT company, which in turn means he earns a handsome salary. In the same breath, the respondent contended that petitioner has a huge income from her personal business and submitted one document showing that she gets 50,000 a month from her business. Lordship, I'm on the next page.
Yes.
When both the parties are more or less solvent and have a reasonable income to pull their own lifestyle, then at this early stage of the case, the main question is about the maintenance of the minor children who are residing with the petitioner. It is true, Lordship, I am just skipping over. Next paragraph, Lordship, I am placing. It is not the case of any of the parties that the opposite party is under clout to maintain anyone apart from his dependent wife or children. Therefore, when the opposite party husband has got a handsome income, and when the opposite party husband has left the minor children with the petitioner, the opposite party husband must take the pain for maintaining his minor children. Under the current economic scenario, if the gross income of the opposite party is north of 1 lakh as stated by him, then I am of the opinion that alimony pendently to the tune of 25,000 a month, 12,500 each, along with one-time litigation cost would be 15,000 would suffice the need of the hour. Lordship, here, Lordship, the opposite party has raised a contention that, Lordship, in his written statement also, that the children were removed from his custody. The wife abandoned him, went away. The children were at one point of time studying in Calcutta Girls' School, Lordship. They were removed from his custody, taken away.
What is your income?
Lordship, it is 1 lakh. 1,15,000. We have stated that in our affidavit, Lordship. We have also stated that the wife also earns a substantial income.
What is the document you have produced that the wife is earning?
Lordship, the wife herself, in the maintenance case before under section 125 of the Criminal Procedure Code, had filed a certificate of her income before the learned court that she is earning 50,000 a month. This is in 2019, Lordship, when the maintenance case.
So here the wife has not been granted any alimony.
Wife,
so you are paying to your children.
Lordship, I am paying already, Lordship, pursuant to a direction that was passed in that application for maintenance under section 1.
You are paying to the
I
children.
am paying to the children, Lordship, 10,000 per month.
There are two children.
Two children. So it was decided that 5,000 each for the children.
So 10,000 you are paying.
I am already paying, Lordship. There are no areas with regard to that. Lordship, but here, Lordship, what has happened is that the learned court below absolutely did not take the obligation of the wife to maintain the children. It has been assumed that since I earn a handsome salary, the court proceeded on that assumption that since I have a handsome salary, I am only duty bound.
After all, your children.
I understand, but Lordship will kindly.
After all, your children, you are a well-off person. You are having a fabulous income. Please maintain the children.
Lordship, I am. Lordship, I do not stand in the way of what is falling from Lordship, but Lordship will also kindly take into account that the wife remove the children forcibly. They were studying in one of the best schools in Calcutta.
How were where they are studying?
In Asansol, in some school in Asansol. Lordship, the cost of a school in Asansol cannot be compared to that of in Calcutta girls. Lordship, when the wife filed the application, I can also show in the same year she had.
Must thank the wife. Otherwise, the alimony will have to be increased then. If she is on Calcutta girls or any other school.
Lordship, husband has stated in his affidavit that while they were in Calcutta girls, he was the one who was paying all this.
The stage of the matrimonial suit.
Stage of the matrimonial suit.
Where is that you have stated that in the maintenance you are paying 10,000? Where is that? Nothing has been stated here.
Lordship will kindly take up my affidavit of asset.
But here you have not stated anything. No submission of yours.
In the revisional application?
No. In the impugned order.
Impugned order that has not come in, Lordship, but in the affidavit.
Made that submission.
In the affidavit of asset, Lordship, I have declared that 10,000 per month I am paying.
But you have not stated that here. Nothing has been by the order impugned.
I am for the petitioner.
Yes.
My application under Order 7 Rule 11 petition was rejected.
What is the suit for?
Put for declaration and permanent injunction. My lord,
why the suit is barred according to you?
Please, at page number 14, I have annexed the plaint.
Yes, why the suit is barred? What is the ground?
Because they have taken different pleas and different cause of action in a suit. They have once they made out a case that their tenancy will be protected. They are tenant in a portion of the property. They claim for they have entered into an agreement for sale, and thereafter they claim that they have mortgaged. They had lent rupees 40 lakhs. My lord, paragraph number 11 to 15. They have taken injunction over the whole property. They want to get relief under the West Bengal Premises Act, Transfer of Property Act and mortgage.
Where is your application on order 7-11?
Yes.
And 3595 page.
Page 95.
95.
Annexure
P5, P5.
P5.
Yes. Anything more?
My lord?
Anything more?
No.
Want to submit anything more?
No.
This application under Article 227 of the Constitution of Yes.
The defendant is the petitioner before your lordship in a suit initiated for partition, where I do have a counterclaim. I stated that there is a already registered deed of partition between the parties. So, my lord, there is no question of further partition. But the lot C was allotted by virtue of a mutual arrangement. Since the lot C, there was already a construction when I was at Durgapur by the other co-sharer. So, my counterclaim is that instead of lot B, the lot C should be allotted to me, where I have already raised construction. So suit dismissed since they have not proceeded. Counterclaim decreed. Thereafter, that counterclaim, the execution case levied. They filed an application under Order 9, Rule 13. In 2022, the examination of plaintiff's witness started. That has not been
in the miss case.
In the miss case under Order 9, Rule 13. That has not been completed till date. There are two interlocutory applications. I must be candid before your lordship. 151 is on the instance of mine. Since the Order 9 Rule 13 application, they have given a wrong date. The date of actual passing of the judgment of ex parte judgment, that was wrongly written. That's why my 151 technical for dismissal of Order 9 Rule 13 on that ground. They took out an amendment application. So these two also can be disposed of. But I want the Order 9 Rule 13 to be disposed of the miscellaneous case number 47 of 2021.
So Mukherjee, if the amendment is formal, why did you raise objection to that?
I cannot
would have agreed to that. Everything
ought to have.
One application has been filed, objected to, sign.
That your lordship knows, we can't help it. But I find, this is very technical, your lordship directs that.
What? I cannot allow from here.
No. Your lordship direct that. I am not saying that is very risky. For expeditious trial of these two interlocutory application and thereafter the miss case.
When the suit was decreed?
Suit was decreed, my lord.
This application under Article
19th of September 2019.
Under Article 227 of the Constitution. Yes.
Lord, I am submitting affidavit of service.
Affidavit of service, why? There's a caveat.
No, my lord.
Why have you served then? There was a direction to serve.
No, my lord. This
Why have you served?
Lord, to expedite the proceedings, just. Lord, in a suit for injunction, and
Then it is a difficult thing. Since you have served, there is a resolution of the bar association. You have complicated this issue. There was no necessity to serve. Once you have served, not today.
Lord, then Friday, make it Friday. Friday, on Friday.
So Friday, it may be difficult. Tomorrow, because of these resolutions, otherwise, once it is adjourned, it's adjourned.
Monday, my lord. I shall be
Sir,
on
if you
leave.
pay for that adjournment, it will be adjourned. It cannot be, might not be taken up on Monday. Choice is yours. For this unusual day, I can make it only not today. Yes, call the next matter.
I have a question, my lord.
Yes,
Thank you.
that-
My lord,
you are for the petitioner.
petitioner. My lord,
Oh.
I was thinking that you are for the opposite part.
my
Yes.
lord, before traveling with the papers, just the background. The petitioner is a decree holder in respect of 20 bighas of land. We put the decree into execution. When we put the decree into execution, ALW, a company, my lord, filed an order 21 Rule 97. It travelled up to this honorable court. And their rights, pending their rights, my execution in respect of that entire 20 bighas, my lord, so far as their possession of 60,000 was stayed upon payment of occupation charges. Went up to Supreme
Mr.
Court.
Banerjee is opposing this.
Yes, Lord.
You are appearing.
Yes, I have
ALW. Instructions to appear. I don't have a caveat.
It doesn't matter. He is ALW. He is the person at whose instance, Willard. I don't think he has anything to say in respect of the reliefs that I'm claiming, but obviously it's up to him. So, Millard, the court said that so far as his possession is concerned of 60,000,
You cannot proceed with the execution.
so far as 60,000 is concerned, balance you can proceed. We go back before the trial.
And they were directed to
The
put in occupation charges.
which has been affirmed till the apex court. So that portion is over. He is in possession. That's a separate fight I am fighting. Now, I told you, Lordship, Millard, the entire area of land was 20 acres. His right is restricted to 60,000. Now, we find that the balance portions which are vacant and Millard, they were being tried to be encumbered by the decree holder himself. A judgment debtor itself. Sorry. Sorry. So we made an application, Millard, for appointment of a special officer to go and inspect. Special officer was appointed. He was directed to file 2 reports. He has filed reports which clearly indicate, Millard, that so far as the balance area is concerned, that is being encumbered by
Mr. That without interrupting, that 16,000 square.
60,000.
60. That's the constructed area.
Constructed? Yes.
That's the constructed area.
And rest is vacant?
Butted and bounded anything or?
No. No, it's not butted and bounded.
And
but
the
this
rest
is that
portion is the vacant land.
It's ascertainable. It's ascertainable. I have annexed a map and the special officer has also ascertained which is the vacant portion. There is no challenge to that. Now, Millard, vis-a-vis this, Millard, when I go before the trial court and the special officer indicates by taking photographs that yes, there are encroachments like keeping trucks, trawlers, parking them on the road, leaving it there. So, Millard, we made an application, Millard, subsequently that so far as the vacant area is concerned, leaving is 60,000 obviously, Millard, that the special officer should take possession. Because otherwise the property is being wasted and damaged because of this continuous of execution proceedings which is going on since 2010. Millard, umpteen number of dates, Millard, I don't know how, Millard, this goes on and on. A decree which has been affirmed till the appeal court, the decree judgment debtor is not challenging. His rights are separately kept. So far as the balance land, there is no impediment as such to take possession.
So, my lord, now
That can an execution case proceed in a piecemeal manner?
no, my lord, it's not a piecemeal manner. So far as
With regard to the balance, you want to execute that decree.
yes, because my learned
So
friend,
whether this decree
that
can be
that has been clarified.
separated, one portion possession can be taken.
আরে কোটেই তো বলে দিয়েছে পারে my lord, kindly come to apropos this, my lord, page 129.
129. Mr. Chatterjee is also
Yes, my lord,
is also in this matter. So Mr. Chatterjee is the architect, is the brainchild of this separation.
my lord, his strategy is, my lord, something which I realize when I go outside court after losing a matter, that what strategy he has done. I don't get it when he's other side.
Yes.
My lord, page 1, or it's an order, my lord, your lordship will find. That page 1. আরে বাবা পোস্ট না
Which portion?
my lord, page 130, paragraph 3, my lord.
130.
130, paragraph 3, my lord. Your lordship will find the area of land is 20 biga 4 kata 9 chataks. My lord, paragraph 3, fifth line.
So in this, it has been you have been permitted to take possession of the balance area.
Kindly come to page 142, paragraph 27.
What was the impugned order in that civil division?
The impugned order in the civil division. দাও যেটা থেকে ওরা অ্যাপিল এসছে Oh, my lord, I believe that's not part over here.
No, do you have a copy of that?
দেখাও যাচ্ছে আমি তো তখন ছিলাম না I believe, my lord, it's a dispute regarding their right to continue in that 60,000 and quantum of
That was the issue was quantum of occupation charge. Occupation charge was decided by the executing court for staying of the execution by them. That was decided, that was determined. Against that, they preferred division to challenging the quantum. That was the issue.
They are the judgment debtor or the third party?
They are objector.
Object. Order 20.
Third party or the judgment debtor?
Yes.
No, they are not the judgment debtors, they are third parties. Their application is under Order 21, Rule 97.
Who is the judgment debtor?
Judgment debtor is ECE Industries, Electric Construction and Equipment Private Limited.
They are contesting the execution proceedings or not contesting the execution proceedings?
They have, as of no, my lord, they have gone up to the appeal court to challenge the decree of eviction as it is recorded here, and thereafter they have left it. But my learned friend now says that they have filed one application for
one objection.
oh, there's an objection to this application of mine, which is at page 163.
Your application means which
The
was filed by
application
the
by which, my lord, I had asked the special officer to take physical possession of the vacant area, my lord. They have filed an objection to that, I am told, before the trial.
So that was considered by passing the impugned order.
My lord, the learned judge, my lord, had fixed it on
Show me the impugned order.
2nd August without, my lord, giving, my lord, a symbolic possession or protection so far as the vacant possession is concerned. That's my grievance. Page, the last annexure, my lord. 3rd of June 2005.
3rd of June 2025. you are aggrieved by this.
I am only, my lord, for the time being saying that let it be heard. All objections be decided. So far as the vacant position is concerned, let the special officer take symbolic possession of it. So, my lord, tomorrow we know how much of it, my lord, is encumbered, because my learned friend's right is only in respect of 60,000, which the special officer, before the special officer, he has identified. The reports I have annexed that this is my area. Kindly, my lord, come to the
This
report.
order was passed upon hearing the judgment letter, 3rd of June.
Chilo.
Was the judgment letters notified?
Well, all it says is that both the parties have filed their respective
Not
hajiras.
both the parties, might be Mr. Banerjee's clients.
2101 applicant and the
Because Mr. Dutt, if the judgment letter is there, he is the third party. So the judgment letter is interested in the balance portion. So can an order be passed behind their back? Whether they are interested, not interested, they are entitled to be heard.
Of course. So that's the reason.
So were they heard before the learned executing court?
No, Millard, that's the reason I say, Millard, I have not asked for actual physical possession or dismissal.
Maybe whatever symbolical also. Mr. That symbolical also, whether you're entitled to symbolical possession or
Then
not,
Millard,
are they not entitled to be heard?
Of course, Millard, I'm not saying that. I'm not saying that nobody should be condemned. Anad is a principle which obviously I'm not disputing before the court today. Then Lordship will do this, Millard. I have served him here also. I don't find anybody appearing. Let him come.
today is an unusual day. Kindly take it up any other.
Tomorrow.
Perhaps
So you have served him.
Yes.
How have you served him?
Hey, কিভাবে service করেছো?
There was no caveat.
No, I got a copy. That's why I am very meekly sitting. I don't have a right of audience as of now.
Because there was no caveat.
There was no caveat.
না কিন্তু কথাটা যে জজ সাহেব বলছে যে সিম্বলিক পজিশন
কি ভাস্করদা অ্যাজিউম করে নিয়েছো কোর্ট অ্যাডমিট করে নেবেন নাকি অ্যাজিউম করেছো যে তোমার রিভিশন অ্যাডমিট হবে সার্ভ করে দিয়েছো
সেটাই তো বললাম যে ডিগ্রি হোল্ডার আমি তো ডিওতে জাজমেন্ট কি আর বলবে কিন্তু জজ সাহেব বলে তাও ওকে শুনবে না একবার সেটাই
Yes, Mr. What is your instructions?
No, Millard, what he is trying to say is what I said, because what can a judgment letter say in execution of a decree which he has suffered and that has achieved finality?
You said they have filed an objection against this. So if they have filed an objection rightly, maybe that can be rejected. Are they not entitled to be heard? You are taking possession, whatever right they have.
তাহলে ওইখানে করি দাও So, Millard, can I have this, Millard? Since I don't have an answer to that they should be heard before. Millard, only prayer is, Millard, kindly prepone this hearing on a day so that they can be heard and disposed of. Because this execution is pending, Millard, since 2010.
That application.
That application.
2nd of August, Mr. Dutt, how can it be preponed? Today we are on 8th, 9th. Almost a month, Mr. Chatterjee. It's difficult. Preponing, I do not know the business of the court.
They have filed the application on 2nd July.
It's very
3rd July.
And it's also very difficult within a month.
2nd August শুনে নিতে তাহলেই তো
That's the practical difficulty.
এই ঘাট ডাউন করার জন্য
That's the practical.
না
ওখানেই যাবে তো
Millard,
Millard, kindly appreciate my predicament, Millard, and fix it on very well. Millard, second up, no adjourn.
Yes. The difficulty is that if you ask me, as you know, urgent matters, I also cannot fix within a month. That's my difficulty.
Millard,
So, nothing. 2nd of August, preponing other things, I think it's better. And directing on 2nd of August, without giving any adjournment to be decided.
Yes. Without taking any adjournment.
After some argument, Mr.
এখন সিম্বলিক্যাল পজিশনে থাক তোমার সাথে আমি বলতেই পারি
Your Lordship, Millard, this is
internal
matter goes on.
After some after
That one of the learned judges had told me that the actual game begins in an eviction after the decree is passed, not before that.
কে বলেছিল ভিভিয়ান বস কে
Lord, father, before your lordship, Lord, in the Act 8 case, tell your lordship, Lord, it was initially filed in Bangalore. Parties were living in Bangalore. They are both techies, Lord, living in Bangalore. I am praying for expeditious disposal of the case only. Because it was filed.
Page of this Act 8 case.
Lord, Act 8 case, the last application that is pending, filed by me for a visitation right of my parents, grandparents visitation right to the child. Now, Lord, after your lordship's direction only, it will be taken up for hearing. Lord, it's at the interlocutor stage. Now, kindly come to the certificate
it is
copy.
fixed?
Lord, last it was fixed on 30 June.
What is the next date fixed?
Next date fixed.
This application under Article 227 of the
Child is already 8 years old. It's filed in 16 in Bangalore. Got transferred from the Supreme Court by the wife. I was 1 year. 1 year. Time, very. Without granting any unnecessary adjournment, my lord, without granting any unnecessary adjournment.
Yes, without granting any unnecessary adjournments to either of the parties.
I am for
Mr. Chakraborty, unnecessary means bar association resolution is not necessary. That is not necessary.
ওখানে তো এরকম হয় না, ওখানে no one appears.
I will clarify that. What does unnecessary mean? That is excluded.
Here some of us appears, but in the trial courts, no one appears.
But the difficulty is that you will prefer adjournment on that ground and come up with expeditious. That creates the problem. That creates the problem.
But after this order, something will be expedited. Now,
I'm not talking about this matter.
yes, absolutely.
So
Now people
overall,
take advantage of the not to attend resolution in the trial courts.
no, that is one way. If you take advantage, take advantage. Nobody is.
Then you cannot come.
Now you are coming to pay for expeditious hearing.
Then you cannot come.
So it's difficult for the judicial
In
officers to
trial courts
function.
also, when you go from here, they don't allow. The judges don't allow. I tell you. In one of the matter, I went to Barasa. The judge said, no, I cannot take it up.
Yes. Which
My lord,
who is appearing?
I am for the petitioner. I am for.
Yes.
My lord, see the order number 15. Order date 23rd March 2023. My plaintiff petitioner filed
Want expeditious disposal of the partition suit. This application under Article 227 of the Constitution.
But we are for the opposite party, my lord. The only thing is, my lord, you were on KBS, but we have not been served also.
None appears. Not today. Next.
My lord, 19, my amendment application has been rejected.
Amendment application rejected.
Why? In the suit, I prayed for only injunction. In the counterclaim, they claimed for right over the suit property on virtue of another deed of gift. Thereafter, I prayed for amendment and that has been rejected. Amendment petition is at page 29. Amendment petition.
Where is your plaint?
Plaint, page 10. One Kamalabala Sarkar was owner of 6.6 decimal of land.
What is the amendment application?
Page 29. Suit was only for injunction.
prayed for amendment to declare my right over the property and to declare their deed as null and void.
To declare the deed as null and void.
Their defendant's deed. Because they are claiming their right over the property on basis of that deed.
Where is the written statement?
Which one?
Where is the written statement? They have claimed this
My lord,
title by
written statement as page 13. Thereafter counterclaim at page 20. Paragraph 17, page 15, paragraph 17 of the written statement. And at paragraph 25, they are stating that they have lost it in tsunami while he is on Andaman.
Show me their written statement wherein they have claimed title with regard to that deed of gift.
They have filed counterclaim.
Yes, show me that.
Page 20. At page 25, their prayer for declaration of the defendant title.
No, averment, show me that. So there was a previous suit.
That suit not between us. Between Kamalabala Sarkar and another.
Trial comments? No.
No.
So that deed of gift was executed by whom?
Kamalabala Sarkar. My case.
Your predecessor.
No. Kamalabala Sarkar was the owner. She gifted it to her granddaughter. From granddaughter, we purchased it. My husband. Thereafter, husband gifted it to me. They are saying Kamalabala Sarkar gifted to his son. So, thereafter, she cannot sell it.
By the order impugned. The
I'm appearing on behalf of the plaintiff petition. This is an
Yes.
application for expeditious disposal, my lord.
Of what?
A suit for declaration and eviction. Suit initiated in 2009, my lord.
So it is what at what stage?
PDW3 is going on, my lord. Kindly the 82 order number 8.
How many more witnesses are there? Why have you filed an application for expeditious hearing of this? So the
Kindly come to my 82 onwards, my lord.
application under Article 227 of the Constitution.
for the petition.
Yes.
21, my lord, I am for the defendants, my lord. To view matters, my lord.
Plaintiff is the petitioner before your lordship in a suit for declaration and permanent injunction. There, my lord, I enjoyed the ad interim order of injunction which was made absolute. But if your lordship once looks at the plaint, page 20 of my lord's
What
brief,
has happened thereafter?
my lord, the miscellaneous appeal has been allowed, my lord, thereby vacating, my lord, thereby vacating the order passed by the learned trial judge of the temporary injunction.
Ad interim
Initially granted, thereafter made absolute.
Up to the appellate court.
No, there is no challenge. Thereafter, they contested that order was made. No, my lord, they initially contested but did not appear. Thereafter, the initial order of ad interim injunction was made absolute. And thereafter, the appeal was preferred. Before the miscellaneous appellate court, the appeal has been allowed. So, initial, my lord, there was no challenge, no written objection before the trial court. My lord, if your lordship takes up the plaint, my lord, why the page 20 it starts, my lord, kindly takes up. It's, my lord, the
What is the suit for?
Suit is for declaration. My lord, there are, my lord, my case is that there are two owners in respect of the suit property. From one of the admitted co-owner, my lord, I have purchased the property. This is a pawn.
So you are a co-sharer.
I become a co-sharer. My lord, my prayer is, my lord, kindly takes up page 23. আবেদনের হেতুমূলে তপশিল সম্পত্তিতে বাদীগণের 66 শতক অংশ সত্য সাব্যস্তদের আদেশ দানে আর্জি page my lord 23 of my lord's brief.
23, yes.
Yes. Lord, first is for Lord, my declaration of my title in respect of 66 sataks in respect of the suit property. Next is তপশিলে মূল বিবাদীগণ এবং তাহাদের সহযোগী ব্যক্তিগণ যাহাতে ভবিষ্যতে বাদীকে বেদখল করিতে না পারে বা তথায় মৎস্য চাষবাদ করিতে বা মৎস্য ধরিতে বা দখল করিতে না পারেন উক্ত মর্মে চিরস্থায়ী নিষেধাজ্ঞার আদেশ দানে মর্জি হয়. So my lord, they are disturbing.
Are of the co-sharer.
No, I'm coming, my lord. No, that is totally
are the co-sharer.
In my plane, defendants are nobody. They don't have any right, title, and interest in respect of the suit property. That is my case made out in the plane. Lord, I shall.
Where is the written objection?
No, Lord, there is no written objection of the injunction application before the trial court. That's why, Lord, if your lordship takes up, Lord, now the ad interim injunction.
In the miscellaneous appeal, they have filed a stay application or some sort of.
But I will take your lordship to that. Lord,
what is their case? What is their case in the stay application before the miscellaneous appeal?
Lord, the memorandum of. Lord, if your lordship takes up page 59. I will say page 50, Lord, page 56 it starts. Lord, its content both, Lord, the statement as well as ground. Paragraph 7, if your lordship takes up page 58, has your lordship got it, my lord? The last 5 line from the top. It starts with 4 line from the top, from the bottom, my lord, sorry. It is to mention here. Has your lordship got, my lord? This is
Please give me a minute.
Lord, I am sorry. Oh, sir, I'm sorry. Das and Krishna Das are the Lord, two co-owner. I purchased from Krishna Das. I say you are no one. Lord, kindly takes up their memorandum of appeal. Your lordship perhaps not have already noticed page 58 bottom, which I wanted to place before your lordship. What case they have made out for the first time before the appellate court. Lord, full line from the bottom.
They have made out this case for the first time because their allegation is that they went to serve.
I'm not on that. I'm not on that, Lord. I'm not on that. The court has not. Kindly takes up, Lord, page 58, full line from the bottom.
Yes.
It is to mention here that the plaintiff suppressed the material fact that the
claiming
suit tank,
settlement.
yes, could not able to prove. Lord, I shall show that. Now, my lord, what is the observation of the appellate court? Now, kindly takes up decision with reason. But I have not disturbed your lordship regarding the interim order, which I enjoyed, my lord, since from 2023. Now, kindly takes up, my lord, the decision with reasons part, page 4 of the order impugned, my lord, without reiterating the other portion. Second paragraph of page 4. Learned advocate for the appellant further submits that if the plaintiff's respondent has exclusive possession over the suit property tank, what made them apply before the government seeking permission for catching fish such and such? He further relied upon CS RS Porcha, from where it will be evident that the predecessor in interest of the appellant defendant, kindly marks this portion, my lord, had common right to catch fish from the property, which is though recorded in the name of the predecessor in interest of the plaintiffs as in possession, but also to use for common people. It ought to have been, my lord. So the record of rights, it has been shown the পুকুর is সর্বসাধারণের ব্যবহারযোগ্য. The next paragraph that has been recorded. Yes. And my lord, the court reiterates, relying upon 2016 to ICC, that the suit for partition, wherein my lord, the concept is that until and unless you brought on record all the co-sharer into the hotspot of the suit, so you cannot ask for any interim relief in aid of a partition suit, which is defect of parties. Lord, my suit is not for partition. The court went on relying upon the principle of that judgment, ultimately held in page 5, last paragraph. Accordingly, the materials on hand in the instant appeal does not justify any interim order to injunct any person who when common man has admittedly the right to use and fishing the suit tank. The dispute of land does not justify passing of any order of interim injunction against the defendant in the absence of all other interested joint possessors. Now, my lord, turn over the page 6, the learned judge set aside the order passed by the learned trial court.
Show me the order of the trial court.
Yes, my lord, kindly takes up, my lord, the detailed order of the trial court is at page 49 of my lord's brief.
That is the temporary injunction.
That is, my lord, the ad interim, because thereafter, which was
temporary, nothing has been done, only
yes, since there was
so reasons is in the ad interim.
Ad interim, my lord, page 49 of my lord's brief. Yes, I will take your lordship even after the RS operation. There was a 44(2)A proceeding under the Estate Acquisition Act. In the record of rights, the সর্বসাধারণের ব্যবহারযোগ্য, my lord, that, my lord, common right of user has been deleted. And in the LR record of rights, nothing is being mentioned with regard to that it is a common user of all.
But Mr. Mukherjee, the difficulty is that neither the trial court nor the appellate court has entered into that.
Yes, that those record of rights are there. They have exhibited.
Show me the finding, court's finding, trial court's finding with regard to that.
Kindly read on.
Yes.
Prior to the ordering portion, on careful perusal of the application, has your lordship got it?
Yes.
And further, having considered the submission of the learned counsel and having gone through the RS record of rights being number such and such of Mouja, Damra, plot number, plot information report in LR plot number such and such.
What is the finding? Says upon consideration of this. What's the consideration?
Lord,
how the entries were interpreted?
Lord,
nothing.
Lord, if that be so, my lord, today before the revisional court, if it is the order, ultimate conclusion is justified, your lordship can always, Lord, it is not the finding of the learned trial court, appellate court also, that it is not.
This is why I am saying neither the appellate court nor the trial court has
the record of rights stands in my name. Kindly takes up the LR record of rights now.
So, Mr. Mukherjee, neither the appellate court nor the trial court
has given. He has perused the record of rights and found my right. Because kindly see, my lord, once LR record of rights.
Record of rights. Mr. Mukherjee, consider this and I find this.
If their name is not there, what should be recorded?
That has been recorded there. Their name is not there.
No, there is, kindly takes up page 41 once.
Yes.
Had it been a case that there are other entries, then there could have been a justification that why the learned judge is not saying that only this person's name, why has not been recorded. Kindly takes up page 41 and 42 once. Page 41 is 505 and 42 is plot number 780. These two is being recorded, Ram Prasad and Shiva Prasad. Shiva Prasad is the plaintiff before your lordship. This is the record of rights standing as on today. There in the Montobbo column, Millard remarks, there is nothing mentioned. And their case is that they have obtained lease from government. Page 41 and 42, a learned judge, upon perusal of these records as on today, there is no mentioning with regard to that remark column that it is for user of common people. And if they want to, there is, yes, I'm coming, Lord, that's why.
40 there is Sadharane Bhavarjo, that is
that is in respect of kindly marks
780.
780. This has been done in 44. Kindly takes back to page 39.
39, yes.
Kindly takes up. This has been done under section 44(2)(a) because prior to that, both of these plot were Sarvo Sadharaner Bhavarar Jogyo. So thereafter, after revision 505 Pukur, there is no mentioning of Sarvo Sadharaner Bhavarar Jogyo.
500, 505.
505, Millard, this is one of the plot. And Millard, in the LR record, after that, this Montobbo column is entirely deleted. I could have understood, Millard, they have taken a plea that on the basis of record, they are seeking their right. Their case is of that, they have taken, Millard, lease from the government.
Where is your, you have purchased?
Yeah, I'm purchased. I have
Where
purchased.
is your deed?
Yes, Millard, kindly takes up my deed. Millard, page 43 of my Lord's brief.
Yes.
From Millard, I am the Grohita, Ram Prasad. Krishna Das, one of the admitted co-sharer, have transferred his share by virtue of a registered deed of 82. My name find place, Millard, in the LR record of rights. The schedule is at page 45. Page 45, bottom, Millard, your lordship will get the
Have
two
you
plot
seen
numbers.
the handwriting in the deed?
Yes, very nice.
Even better than the computer
Print out,
typing.
yes. Today in our institution, Lord, Mr. Royce Jr., Lord, I must say, Mr. Shannal, his handwriting is very nice, very nice.
Yes.
So, Lord, upon consideration of this and the LR Porcha, Lord, I have shown before your lordship, I am not repeating myself. Lord, the court has come to a conclusion. A case made out by the defendant for the first time appellate court is that they are in possession or they are claiming their right through a lease executed by the government.
The appellate court says,
kindly see the appellate
page 4.
My lord.
Admittedly, some of the parties are in joint possession in partially vested property.
Yes, yes, because my lord, your lordship will get Lord, some portion is being vested. That
of that pukur.
Of that pukur. Some portion. Lord, that's why they made out that case that they are in possession through the lease by the government. But could not able to show that.
So, what is the total area of the tank? What is the suit property? Sir, I will come back to you. Yes. What's the total area of the pond?
Kindly.
What's the suit property for?
Kindly now takes up, Milord. Just after the certified copy, your lordship will get, Milord.
The total area of the pond is 5.55.
Milord, kindly takes up, Milord, just after the certified copy, the record of rights is being
show me your plain.
Plot information report.
Please show me your plain once.
Plain, Milord. The schedule is at page, Milord, 23.
Yes, page 23. Most 5.55 acres.
Acre বাদির অংশ 46 দুইটি দাগে 66. Now the segregation which your lordship is wanting, that your lordship will get just after the certified copy. I have annexed the plot information report. The certified
page
after the certified copy of the appellate court judgment. This, Milord, plot information report just after the memorandum dated 28th October 2024, your lordship will get the record of right.
Yes.
This is the current one. Here your lordship will get, milord, the Pukur, milord, Poschimbango Sarkar, milord, the Poriman, milord, Angsho Poriman is being written. And next is, milord, the plaintiff, Ram Prasad. And next is Shivdas. Shivdas to no.
Yes, so
this is, milord, in 505. The next one is 780.
so the area is 2.34.
So that is, milord, in respect to 505. Can you turns over the page 780, your lordship will get 5.55.
That is 780.
Yes, milord.
So the suit property is 2 plot.
That's why, milord, the top shield, milord, your lordship, kindly compare it to page 23.
So, Mr. Mukherjee, you have sought for injunction over the entirety, a portion of which is vested.
No, I am not seeking any injunction against the government.
Mr. Mukherjee, if you are not seeking relief against the government,
I say, milord, this
portion is a vested plot.
Very well, milord.
So if it is a vested land, so how that can be demarcated? Which portion you have a right?
No
which
necessary.
portion you do not have a right?
Right. I am seeking in respect of injunction in respect to a person.
Mr. Mukherjee, you don't portion of that pond, you do not have any right to claim injunction.
No, I am not claiming. Kindly
You have
take
claimed
up
injunction against the entire
my 66 shataks.
I say, Mr. Mukherjee, 66
cannot be.
Mr. Mukherjee, 66 is out of this 5.55.
Milord, may I just, milord, give an example? Today, suppose, milord, myself and 3 other co-sharers are there. Being a pond, we cannot ask for, milord.
That's the difficulty.
I'm coming.
That's the difficulty.
I'm coming, milord. Today, I cannot seek for any partition in respect of that pond in apropos to my co-sharers.
And the vested portion is the larger area.
It will come, milord.
It's a larger area and
I will come, milord. I will come. I have to answer your lordship's query, milord. Today, myself and 2 other persons are the co-sharer in respect of a plot. As per law, milord, we interse between the co-sharer cannot ask for partition. We are not seeking for. What? For the tenure of interest of all the co-sharer, I filed a suit asking a third party who don't have any iota of right to the pond, seeking for an injunction. Please do not restrain them so that they cannot disturb my pisciculture. Can I not do that? That will be inured to the interest of other co-sharer also. It is not a case that the other co-sharer comes and join, that why you can seek for injunction against us. Really, I am not. What I am seeking a third party who is disturbing in my pisciculture, who don't have any iota of right title interest. Can the court do not have that?
In a vested pond, Mr. Mukherjee, major part is vested. Small part is yours.
Milord, again, milord, I am not claiming my entirety. Milord, I am claiming whatever I have got by virtue of that deed.
Yes.
So today, milord, I am claiming that injunction against a person who don't have any iota of interest. So they have, that's why, milord, consciously they have made out a case that yes, state of West Bengal has granted me that lease. On the basis of that right, I am occupying. They could not be able to prove that.
That is their right. You cannot restrain them.
I cannot. But they will have to show that at least prima facie before the court, milord. I will bow down. Because the state...
Yes, anything more? Yes. What is your right in the pond?
Milord, kindly see the page. After the judgment of the appeal, Milord, kindly see.
Yes.
It was reported by the BLRO to the my lord additional district judge redesignated court Bankura, sent by the BLRO.
Yes, this is the plot information, no dispute.
Yes, my lord.
What is your in that point? Show me.
My lord, there is no page marking after that. My lord, Motsod Dhorbar Udhikar Ache.
Show me your right that you have a right to catch fish. Show me.
My lord, we have settlement from the government.
Show me that.
Kindly.
I want to see that. Show me the settlement by the government in your favor.
Number 212.
Where is that? last page, my lord, of this, of their. Of the civil division application?
Yes, yes. I have stated everything in my.
Where is your name recorded? Here your name is not recorded.
My predecessor interest of my defendants.
Where have you made out that case? That your predecessor in interest,
My lord, I stated everything in my written statement and written objection.
Where is that? Show me that.
My lord,
No, this written objection or written objection to after
injunction.
disposal.
My lord, I have.
Show me that.
My lord, written statement as well as my lord written objection. I have stated everything, my lord. My lord, the two plots. My lord, one plots.
This, my lord, written objection was as per them. After disposal of the injunction application, they tried to serve. This was not on record before the trial court.
But Mr. Mukherjee, if
Very well, my lord, your lordship,
There are so many
I
questions.
give them an opportunity to file an affidavit in opposition in this.
yes, yes, your lordship can always. So, my lord, I
if there
just,
is
my lord, pointing out.
something- Show me the
This was not
document
before the trial.
with regard to the, where have you made out that case?
My lord, last page of this application. মৎস্য ধরিবার অধিকার আছে 212 খতিয়ান number. My lord, there are two plots. In plots number, defendant has claimed only 20 decimals and another 46 decimal. Total 60 decimals in a big plot of tank. My lord, total area 789 acres. Well, this is a tank, my lord. There are so many course errors. My lord, are course errors in the suit.
You are not the co-sharer. You are not the co-sharer. You
My
have
lord,
a piece.
I am the co-sharer, my lord.
You are the co-sharer.
I am the co-sharer taking by
Sir,
settlement.
you have a co-sharer or you have a right, you have a right to catch fish by way of settlement.
Yes.
This is your right.
Yes,
Are
my
you a co-sharer or you have a right to catch fish by way of a settlement granted by the government in respect of the vested portion?
Yes, my lord.
What yes? I am asking you which one.
My
Are
lord,
you a
can you see-
co-sharer or
this is my only documents here. My lord, I have stated in my
all right?
written statement.
কিছু বলিনি. This application on
There was no.
That is why motion I have kept it.
But
Please,
not protect
Mr.
me, Milord,
Mukherjee,
otherwise
without looking
they
at
could not able to produce anything of that
Alright, let me
settlement,
see.
even before your lordship or before the appellate court. Not one document at least.
objection, there is something there. That is why I have asked them to file written objection.
No, I am not, Milord, they have to, Milord, even if without written objection, for an iota before your lordship, they can produce something.
No, no.
This is the document of settlement. But Milord, the record of rights subsequently in RS operation changed, their name deleted. Milord, I have shown before your lordship.
File that by way of a reply.
No,
Because
that
the-
is already there.
Mr. Mukherjee, the trial judge did not record anything said.
No, because
Considering this record of
because
rights.
the LR record of rights stands in my name.
All right. The LR record of rights stands in your name, but it also records a portion of the plant is a vested.
But government is not coming, Milord. It's a
Maybe
private party.
If he claims, Mr. Mukherjee, if
He
he
can
claims,
say that I'm claiming through government, but no document before the appellate court or before your lordship.
Mr.
No
Mukherjee, they
document
did
whatsoever.
not get any opportunity. They did not.
Before the appellate court they got.
Before the appellate court, they have only filed an application.
No, in the application,
Yes.
no document whatsoever.
All right. I've kept it on the motion stage.
Milord,
Nothing
Milord,
will
in
happen,
the
Mr.
supplementary list, kindly fix it, Milord. Otherwise, monthly list, Milord, again.
Monthly list, let it appear. Consider motion. Supplementary list, it's difficult to fix a date now. That's the difficulty.
We shall mention, Milord, we shall.
আচ্ছা তাহলে একটা কাজ করে দিন Not today. Yes, Mr. Singh.
I have come up against an order, passed by, London Motor Accident Claims Tribunal. Motor Accident Claims Tribunal. This Motor Vehicle Act, was last amended, 1st April 2022. As per the amendment, the time limit for filing a claim application, is 6 months. It was inserted, section 166(3) from the date of accident. In this particular case, the claim case was filed 9 months after the date of accident. My client insurance company filed an application, for rejection of, the claim case.
There is no provision for condonation.
There is no provision for
or extension of time.
or
nothing.
extension of time, there is no provision. This particular, this time limit, is prescribed, in section 166, subsection 3. This claim case was filed, under section 164. Learned Tribunal judge, stated that since the prescribed time limit is only confined to 166(3), or 166 claim cases, it would not hit 164, and therefore, the
difference between 166 and 164.
In 164, there is a specific amount of compensation, in maximum in case of fixed amount. In case of death, it is 5 lakhs. In case of injury, it is 2.5 lakhs.
No fault liability.
No fault liability. It's akin to no fault liability,
So if it's akin to, so did these stand on different footing, Mr. Singh?
It is, but I'll invite your lordship, to 164, 165, and 166. And this particular issue, is presently pending before Honorable Supreme Court. I do not have the total of the entirety of the
What
order.
has been done?
My 711 has been rejected. Against that rejection, this requires my lord's consideration, I'll invite your lordship, to this page number 12 is, my lord, is at the order of the court.
Yes, I am on the impugned order.
Impugned order, is the last page,
Yes, Mr. Singh, only difficulty is
Lordship.
that if that issue is pending before the Honorable Supreme Court,
Lordship.
it might take time, let it proceed. So if it is, it can be dismissed at any point of time.
What I say, the difficulty is, when one is not entitled to, to file the claim application at all, if my lord has got Motor Vehicle Act, otherwise, your lordship will kindly have a look,
Please,
164.
You have a copy of
Yes,
Motor Vehicle Act, আছে? Amended, এটা লাগবে কিন্তু।
This is marked. Your lordship will kindly have a
That
look.
will help me. Marking will help me.
I'm grateful to your lordship.
Yes.
165, 164 prior to that, it doesn't speak anything about the limitation, 164. It is only about this compensation part. I would not trouble your lordship with 164. 165. The one I have marked with a pencil. The explanation part, if my lord kindly says, the claims tribunal jurisdiction, but in this case, it also includes application filed under 164. My lord has seen, and then your lordship will kindly come to 166, My lord has taken note of 166, The underlined portion, that is, 166 says, the application filed under section 165. Milord, 166(3).
Lordship. 164 starts with a non-obstante clause.
Lordship.
It overrides other provisions.
Well, at the same time,
those limitations.
Milord, I bow down to your lordship, I have understood. But Milord, your lordship will also, kindly have a look, Milord, the specific intention of the legislature. 165 is
that is with regard to 166, non-obstante clause overrides everything. That will have primacy over all other provisions. 7, notwithstanding anything contained in this act or in any other law for the time.
Lordship.
So it overrides everything. It
Lordship.
has privacy over all other
Lordship.
provisions.
Milord, that is correct. 164 does not speak about the time limit, Milord.
And
But-
it overrides 166 also.
But Milord, when once, yes, but when 165.
And this is only with regard to
Has taken 166.3.
Mr. Singh, do you have the pre-amended portion?
Milord, pre-amended, Milord, this 166.3 was not there, Milord, with regard to this limitation part. It was not there.
Oh, this is inserted.
This is inserted by way of amendment of 22. It is coming for the first time. That is
that some amendment or substitution has
no, Milord, earlier there was no limitation. One could come at any point of time. There was no confusion. It is only after the 1st April, Milord, 2022. It has been inserted.
Mr. Singh,
Lordship.
yes, 166.3
Lordship.
is only with regard to applications filed under 166.1 and it will apply to
this is
because please come to subsection 2. You have
Lordship.
another copy? No.
Yes.
No, that are names.
No, Milord, I'm looking into it. Yes, 166.2, I've got it here.
Yes. First, please come to 166.1.
Lordship.
An application for compensation arising of a nature may be made by the person. So these are the persons.
Lordship.
By the person, by the owner, where the date such and such, such and such.
Mhm.
Now, 2. Every application under subsection 1, so it
Lordship.
speaks of only subsection 1 of
My
section
lord.
166,
Lordship.
shall be made upon the claimant. Now, we come to 3.
Lordship.
No application for compensation. So this relates to 166.2. 166.2 in turn refers to 166.1 and 164 non-obstante clause. It has overriding effect over everything.
Milord, but I would, Milord, invite your Lordship, Milord, to that 165. This 165 says that it covers 164 as well as 166.
But it's not an application. This limitation is only with regard to applications. Maybe, Mr. There may be 2 grounds.
My lord.
You are entitled to file, but there is a fixed compensation.
In 164.
So it's a different thing altogether. Maybe for some ground, same ground, you have options to file 2 proceedings. You choose one of the you have liberty. Let us suppose under some circumstances you file before the approach before the consumer forum, or you can.
I understand, Milord. Milord, one has got 2 options. He can choose either of the 2.
Yes.
You can choose either of the 2.
If you exercise 166, 166,
then the limitation comes in.
If you because that is higher amount of
yes, unlimited.
And yes, unlimited 164 is a fixed amount. I will not go to that. So it's the intention of the legislation not to touch 164.
Milord, may I humbly pray one thing, Milord? What had
Not
fallen?
to touch 164.
Milord, what had fallen from your Lordship? Milord, let the proceeding be initiated. Milord, the Supreme Court, Milord, is in session of this this particular issue, Milord. There are various judgments of different high courts, Milord, which are, Milord, are deciding it, Milord, one way or the other. Milord, this is, Milord, the Supreme Court's reference, Milord, which is taken note of these, Milord, problems, whether the limitation would be there or not to be there. Milord, the other details are not here. But other details are not here. But Milord, this is on this particular issue on limitation.
Second, Mr. Singh,
Lordship.
there is also Supreme Court decision which says pendency of a matter before the Supreme Court on an issue that will not preclude the High Courts from sitting.
Milord, I beseech one. Milord, I have understood.
Also there.
Milord, I beseech, Milord, only one thing. Milord, what follows from your Lordship? Let the proceeding be initiated subject to the final outcome of this proceeding, Milord, in the one say this particular case. Milord, in that way, Milord, I believe my client would not be prejudiced. Even the claimant would also not be prejudiced, Milord.
Yes,
that is the intention of your Lordship.
So you
my Lord.
Because I can give any decisions. You have got the contrary views.
Yes, Milord.
164.
Milord, I have got this on 166. This is not on 164. I'm sorry, Milord. On 164 is specific, Milord, in favor of insurance.
On 164 you are having.
Milord, no.
The limited.
No.
The section is clear, Mr. Singh. Section is clear.
Milord, that is what the recording of the learned tribunal judge is also there. Since it is 164, Milord, so therefore,
Yes,
Milord, the
because
limitation would not be.
it has not recorded the reasons after going through these provisions.
Yes.
164 overrides 166, and it will have primacy over all other provisions, not only of this statute.
Milord, your Lordship has recorded that.
So including the
Milord,
limitation.
I understood, Milord. It is, Milord, your Lordship wants, Milord, the claimant should not be felt aggrieved, Milord.
No.
There should not be any delay, and this not, Milord, not standing
that.
what is there.
Pure reading.
Yes.
Pure reading of this provision is clear. that limitation would not hit 164. If you want, I can decide this point here and now. I can direct the other side to come.
Your Lordship will kindly do so. Kindly do so, my Lord.
So this is the point. Nothing.
My Lord, your Lordship will kindly do so, my Lord. I'll serve, my Lord. In the meantime, I'll also hunt if there is any specific judgment on 164 by any of
If you
the.
have any judgment, please bring back. Otherwise,
I'll come back with that. My Lord, I'll come back with that. Your Lordship will kindly, my Lord.
This is absolutely clear. There is no.
I understand. That is why, my Lord, I made everything clear to your Lordship, my Lord.
Ashok.
Oh, bless your Lordship.
It's an interesting point, but I think
it is, my Lord.
please, please.
Because, my Lord, this 165 is there, my Lord, and different courts are passing different orders.
165, yes.
My Lord, 165 is with regard to the, my Lord, jurisdiction of claims tribunal in its entirety. But, my Lord, 164, 166, not with
That's the overall jurisdiction of the claims tribunal.
Lordship.
So claims tribunal can decide application under section 164 as well as 166.
Lordship.
And with regard to grievous hurt or something, so a person claimant has an option either to file 164 or 166.
But 166 unlimited, so that is
Limitation.
why that is why limitation. Unlimited amount, that is why limitation.
So claimant had to be given.
But I'll come back to your Lordship.
Some leverage.
Yes,
for that.
Lordship. Yes, Lordship is correct.
Beneficial legislation is after all a beneficial legislation, and issue of limitation will operate harshly against the.
Yes. In 164. Personally, I believe so. But still, my lord, it is there. I'll come back to your lordship, my lord, with the judgments of the next.
Interesting issue. It has to be considered one way. There is no decision on this.
No, no, I haven't found, my lord, as yet.
When this provision was inserted.
1st April 2022. It's 2 years now, my lord. Still not an issue. But on 166, my lord, there are various conflicting.
166.
There are various
provision is
conflicting.
clear
Yes,
because.
but still, my lord, some courts are allowing. Some courts are allowing, my lord.
Yes, yes. I've
The beneficial legislation.
Beneficial
Giving
legislation
advantage.
limitation cannot be a bar. Supreme Court has deprecated that.
Supreme Court has, but not in earlier, there was earlier in 1988, there was a limitation. Supreme Court in some cases has given advantage to the claimants. But again, there are conflicting judgments, my lord. I'll come back to your lordship, on the next day. We are fine.
Thank you.
Extremely grateful to your lordship. God bless you, my lord.
Yes.
I appear for the petition.
I am for the opposite party.
Yes. The suit was dismissed in 2022. Thereafter, lordship, an application for restoration, lordship, in this case, was filed after a delay of around 243 days.
Order 9, Rule 9.
Order 9, Rule 9. With respect to Order 9, Rule 9, there was a Section 5. The ground in Order 9, Rule 9 and the grounds in the Section 5, they are identical.
What is the
There are
suit
3
for?
grounds. Suit
What
for
is the-
eviction. Suit for eviction.
Under the Premises Tenancy Act.
Premises Tenancy Act. Because the Small Causes Court, my lord. There are 3 grounds principal taken by the plaintiff.
You are for the opposite party.
I am for the opposite party plaintiff. I have explained the delay, your lordship, in the Order 9, Rule 9, as well as Section 5.
I have not been given any opportunity. That is why, lordship, I have
What
come before
opportunity?
lordship.
You did not get any opportunity to controvert.
I have filed my written objection to their application to Section 5. Lordship,
Yes.
three grounds were taken. Number 1,
So what happened to you? You have filed your written objection.
written objection,
So
and I have
why do you
asked
say
that I
you
shall
did-
lead evidence. I shall ask, I've prayed for to lead evidence because I have annexed a document. Lordship, kindly takes page 42. Lordship, they say that I did not know that there were 3 grounds. 1 is COVID. Second is their staff who is looking after left. Third is the ubiquitous manner, the lawyer's fault.
When the suit was dismissed?
The suit was dismissed on 8th August 2022.
8th August 2022.
Lordship.
And when the application was filed?
Application was filed in 2023. My lord, it's
No, COVID limitation
COVID
not apply.
COVID will not apply. Second is the staff left. The staff, no name of the staff, who is the staff, who is the lawyer, no indication in whatsoever in the application. Second, I say that after the dismissal, I have tendered my rent by way of a notice.
That is the different, that is on merits.
Then, my lord, in 2022 itself, they have to have got notice.
That is on merits. So restoration application.
The grounds are same. That is why, my lord, I am on
restoration application you are opposing.
the restoration application, my lord, after 243 days delay. It is.
It's unheard of. Restoration application.
Lordship,
Here with
if lordship will grant us to lead evidence, my lord, because the lordship once lordship will see what is the finding of the trial court, my lord.
So you want some enhancement of cost?
No, my lord, kindly 2 more minutes.
Some enhancing the cost. Be satisfied with that.
2 minutes, my lord. Kindly see what is the second last page, my lord, of the impugned order.
Yes.
In course of hearing, it is submitted by the learned advocate for the petitioner that he shall not adduce any evidence. Second last page, my lord.
Yes.
The second paragraph.
Yes.
In course of hearing, it is submitted by the learned advocate for the petitioner that he shall not adduce any evidence with regard to his application under Section 5, as it is a mere formality. Lordship, later on it is held, it is a mere formality. At this stage, learned advocate for the opposite party submits that he will adduce evidence with regard to the application under Section 5. Where the petitioner does not lead any evidence, the OP cannot seek scope for leading any rebuttal evidence as they
This can be supported.
This
So you have chosen not to prove your case.
Lordship, the proving of the case, your lordship, if your lordship kindly sees, the application, the reasons your lordship has been quoted. Now, reasons have been pleaded.
Reasons is one thing, that is pleading. You have to prove that. He has a right to cross-examine you.
Lordship.
He has a right to cross-examine you.
Why, your lordship, only one thing, your lordship, 2011 suit. These are the old tenants. Now,
That's
2011.
neither here nor there.
I
It was
understand.
dismissed for their fault.
You have invited this.
But it was dismissed. If your lordship kindly sees the application, everything your lordship have clearly mentioned.
Maybe, sir, that is pleading. You have to prove those facts. He has the right to cross-examine you.
I'm grateful, Lordship.
This employees left, other things. You have to prove those facts. Merely by stating will not do.
I have not given any documents to your lordship, which the person has to go in the box and your lordship prove it. I have given your lordship all
the more reason.
Orally, may not be any documents. Orally, if you say something, you have to say that, and he has the right to cross-examine you.
Yes, your lordship. If I adduce evidence, your lordship certainly has the
If
right
you
to.
do not adduce evidence, then you have not proved your case.
Lordship, the pleadings are there. He has controverted the pleadings.
Is pleading sufficient? You file a plaint, you don't give any evidence. You will say, no, 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 I will not give any evidence. I've given my plaint. So other side cannot also give evidence since I have not given evidence. That's the logic. So you are not proving your case. That's pleading, sir. That's pleading. You have to prove your case. You have not proved your case. So that's a ground for rejection. How could it have been allowed?
Your lordship is Section 5, your lordship, in a
Ground is same, sir. Ground is
Helston.
same. Ground is same here.
Should be 2011 suit. Now the problem is nothing. This particular revisional application only has been filed, your lordship, only to stall my entire suit. These people that your lordship, since your lordship long
They
back,
filed
your
their,
lordship, no problem, 6 months.
their application after 2 years.
Let them leave my
2 years.
property within 6 months. I'm giving them 6 months. They'll not leave my property within 6 months. 1 year. But they will want to go till the Supreme Court.
Sir,
your
you are
lordship.
right. Can you take instructions and come?
Lordship.
Can you take instructions on come? I will enhance the cost. Let it be this.
Lordship, I would like to, Lordship, that is my instruction. I have taken it in the morning, my Lord.
Let me see the grounds taken and what is your objection.
Lordship.
Yes.
Kindly sees section 5. The Lordship first sees section page 14, which is the application.
Yes.
Paragraph 5, the then staff was in regular contact with the erstwhile advocate for the plaintiff. The erstwhile advocate was put in sufficient funds and given material instructions in the matter to proceed with the suit and to protect the interest of the plaintiff. The then staff of the plaintiff from time to time contacted its erstwhile advocate to ascertain the progress of the suits and steps, if any, required to be taken by it. On and from March 2020, after the outbreak of COVID-19, the information regarding the proceeding of the said suit for the erstwhile advocate was disrupted due to lockdown. Due to lockdown, the regular functioning of the plaintiff's office was also disrupted, in as much as the strength of the plaintiff's staffs had been reduced to minimum during the lockdown period. On and from February 2022, my lord, there is no explanation in me. The office of the plaintiff company started functioning. In the meantime, the then staff who was in regular touch for the erstwhile had left the office of the plaintiff. There was no one to look after the aforesaid suit from the office of the plaintiff due to such abrupt situation. The plaintiff's directors were also became incapable and disabled to run the business of the plaintiff company during the lockdown period. The directors of the plaintiff company put their focus on the business for survival from the situation that then prevailed during the COVID-19 by its minimum staff. After a considerable period, on and from June 2022, the plaintiff's directors reconsidered the situation of
Where
the
is your
business.
objection to this?
Lordship. Kindly sees page 33. Lordship, page 26 is the section 5. Identical, my lord.
Reasons is the same as you have
Lordship.
said. So show me your written objection.
Nothing remains in this case. That is my one of the grounds.
No, show me how have you dealt with this.
Lordship, 33.
Yes.
Lordship, kindly sees paragraph 5 and 6, page at 34. Further, the petitioner had alleged that due to COVID situation, the petitioner was not able to take updates. It is improbable that the petitioner did not inquire about the present suit since April 2020. Normalcy with respect to various activities was restored since June 2020. The learned court also started functioning. The Honorable Supreme Court also passed several directions in this regard. Moreover, after dismissal on 8th August 2022, the opposite party forwarded a check being such and such towards rent, service charges and car parking, etc. under cover of a letter dated 3rd November by speed post. The said letter was received by the petitioner. Copy of the said letter is annexed. This lordship is at page 42. This was addressed to the petitioner. Therefore, at least in November 2022, the petitioner ought to have found out about the status of the suit. The negligence is entirely on the part of the petitioner and had made incorrect, unnecessary allegations against his learned advocate only to suppress his negligence. This document, I ought to have been given an opportunity to prove. Paragraph 11 is the where I have dealt with the allegations contained in the in those paragraphs, paragraph 6 to 8, Lordship, which I have just read out. Paragraph 11, paragraph 12, paragraph 13 and 14. Lordship, the learned court below was given an impression that the learned advocate did not take any steps.
That's the court's finding on scrutiny of the records also.
From the scrutiny of the record.
It's not on the basis of the allegation. Court scrutinize the record. This is the positive finding.
That no steps had been taken.
By the advocate.
By the advocate.
So,
but my lord,
this is the finding.
That is the finding, but my lord, from 2020,
sir,
everything started functioning. But my lord, nothing now.
But this is the advocate. For the maybe the advocate, can a client suffer?
But page 42 is stated with their face, my lord.
Sir, he did not prove anything of his. This is sufficient.
Lordship, kindly see page 42 once.
From the records. If it is evident from the records, this has been found by the learned trial judge, which is evident from the records. What more he will prove?
Lordship, page 42, Lordship, kindly sees.
Yes.
Kindly sees, my lord. Page 42 once.
Yes, yes.
For my satisfaction.
Yes.
Whom is it is addressed to? This is the defendant writing. It is my letterhead. And whom this has been addressed to? This is not the advocate to whom I am writing.
No. What is this?
This is the plaintiff, Lordship. I am giving the check for the rent. Yes. But in 2022, I have tendered rent.
Yes.
But they have not taken any steps. At that point of time, even then,
the tending rent, that is neither here nor there. How does it relate to this taking of the steps in the suit?
Because, Lordship, I was paying rent in the court below.
Did they accept this?
They accept this notice.
Yes. So what are you trying to suggest from this? They have accepted.
Number one, he has.
So what will happen first?
Conclusion
from this.
The conclusion is, my lord, I was paying rent in the learned court below, as per section 7(1), my lord.
Yes.
Once I started tendering rent to the plaintiff directly, Lordship, they ought to have found out that why the check has been given. Lordship, I ought to be given an opportunity to prove my case by way of leading evidence.
Let us assume all his submissions are false. But court from the scrutiny of the records arrived at this finding that the advocate is at fault. This is that is not even their case. That's not their case. But it's evident from the records.
But that record is even not before your lordship, my lord. Even I have not checked, my lord.
You ought to have checked. I have to go by this recording. If you say that is wrong, you have to file an application for review of this order. If you say that it does not reflect the correct facts, because I have to proceed on the basis of the recording made in the order.
I think I have that's one of my grounds, my lord. Lordship, in that case, my lord, may I check bring the certified copy
of what?
Of all these records, my lord.
If you say that this is not the correct facts, then the remedy is by way of a review, not a revision.
Or even my lord, by revision also, my lord, lordship can give me an opportunity to controvert all these facts, my lord, by leading evidence. Today, my lord, nothing remains with the order of the miscase.
Evidence. This is the recording from the record itself. Let us assume that all your statements are correct, his statements are false. But the court comes to a finding from the record, advocate did not intimate them. That is also not their case. So it's
And-
evident from the records.
It is evident from the record, number one. But the plaintiff themselves got to know. They got a notice. But
This
that
is
has
the
been
court's
suppressed in
finding.
the application.
The court's finding after looking at the records that the advocate did not intimate them.
Advocate did not intimate
So
them.
that's the
Lordship,
finding.
there are twofold responsibility: the advocate as well as the client. The advocate did not inform. That is very well. Let us accept. But what about the client's responsibility when they got the notice? Even then, they did not inquire what has happened to my suit. Why is
Now
the tenant?
live streaming is on. All these recordings will be available. So when you will be coming to those, making the other submissions, that for fault of the advocate, I should not be penalized.
But my lord,
So this,
but my lord, only one prayer, my lord, because the miss case has been now, my lord, nothing remains in the miss case. For the same reason, the grounds are same. The section 5, the same grounds are taken in the miss case. The miss case will be automatically allowed, my lord. That is why, my lord, an opportunity be granted to us to lead evidence. They let them not lead evidence. Then, my lord, at our risk, my lord, lordship, let us lead evidence. And my lord,
what your risk? If you are allowed to lead evidence, they have to be given first a chance to lead evidence.
if they do not, if they do not wish to lead evidence, my lord, that will be at their risk, my lord.
Yes, what do you say?
Section 5 application, not the order 9 rule 9.
Only for the
Ground
same
is the
grounds.
Ground is the same.
I understood. Your Lordship, kindly take, he has hopped on page 42. Lordship, kindly sees page 42. Have they ever said, Your Lordship, that the suit has been dismissed and that's why I'm sending you the rent?
Yes, show me your section 5.
Your Lordship, kindly sees.
And this letter has been
Your
suppressed
Lordship,
in
at
section 5.
Page 26.
So you cannot lead evidence in the miss case unless the section 5 is allowed.
Not sure. Unless the section
5 is allowed.
But, my lord, since the grounds are same,
Sir,
irrespective of whatever, my lord.
Section 5 is not required to be, evidence is not required to be laid. Unless the section 5 is allowed, main matters cannot be entered into. So I am deciding the section 5 first. Make your submissions on section.
Because only section 5 has been,
You are
my lord.
allowed to lead evidence in the miscellaneous case unless section 5 is allowed.
Order 9 rule 9 has not.
I wanted to lead evidence in section 5 only, my lord.
Section 5 on affidavits. Section 5 on affidavits.
Then, my lord, lordship will
Make your submissions on section 5 because you want to lead evidence in the miscellaneous case under order 9 rule 9. Please make your
No,
submissions.
I wanted to lead evidence in section 5, my lord.
Section 5, you have filed affidavits. That's on affidavit.
That's
Here
on
filed
affidavit, my lord.
so it will be,
Then lordship will kindly see what is the finding
yes,
with respect to the letter.
Yes.
Where the petitioner does not lead any evidence, the OP cannot seek scope for leading any rebuttal evidence as there is no evidence to rebut. Moreover, an application of section 5 praying for condemnation is a formality and must be considered liberally by the court.
Yes.
It is to be seen by the court whether there is any reasonable explanation. The miss case must be heard on merits rather than laying stress on the primarily according to the petitioner. There was a letter of communication between the learned advocate and the petitioner.
Yes.
Primarily, according to the petitioner, there was a letter of communication between the learned advocate and the petitioner, which caused the petitioner, who was the plaintiff in the original suit, in taking steps in the suit, which caused the petitioner, who was the plaintiff in the original suit, in taking steps in the suit, in which caused the suit to be dismissed for default.
Miscellaneous case is pending.
Miscellaneous case is pending. But, my lord, if this finding, lordship, that whether there was a letter of communication between the learned advocate and the petitioner, which caused the petitioner, who was the plaintiff in the original suit, in taking steps in the suit, which caused the suit to be dismissed for default. On scrutiny of record, it appears that this learned advocate for the plaintiff has not taken any steps. So, my lord, if these two paragraphs are read, lordship, it appears that the court below thinks that my notice was sent to the learned advocate of the plaintiff. But it was sent to the parties. So this reasoning, with this reasoning, my lord, no matter of evidence, whatever evidence I lead, my lord, I shall be barred.
Which portion?
The primarily according
to the petitioner. This portion, primarily according to the petitioner.
According to the petitioner, thereafter, on scrutiny of record, it appears that
there was a letter of communication between the learned advocate and the petitioner, which caused the petitioner was the plaintiff. Where is that letter of communication?
There is page 42.
Page 42.
This is post dismissal.
No, this is not the letter by the advocate.
Exactly, my lord. Exactly. So, my lord, this thereafter kindly sees the next paragraph. On scrutiny of the record, it appears that this learned advocate for the plaintiff, this learned advocate, as if the letter was issued to the learned advocate, has not taken any steps on behalf of the plaintiff for a prolonged period, and also not intimated the court that he tried to communicate with his client, despite which his client, that is the plaintiff, did not contact to him to give instructions regarding the suit. It is also the duty of the advocate to send notice and intimate his client whether before he withdraws. We do not know whether the advocate has actually sent any notice or informed or not. Having lack of communication from the end of advocate for the plaintiff, the interest of the plaintiff being a litigant must not be allowed to suffer. So, my lord, the entire finding, lordship.
Where is the paragraph with regard to this annexure? Yes, I've got it.
This is the lordship on scrutiny of record.
After the dismissal.
Primarily and then on scrutiny of record.
Party forwarded a check.
And thereafter, Article 21 of Constitution of India has been referred. And it has been allowed.
No, this is the letter annexed in your written objection.
Yes. According to the petitioner, there was a letter of communication. So, lordship, this should be according to the opposite party. There are certain wrong recordings, my lord. Primarily, according to the opposite party, there was a letter of communication between the learned advocate and the opposite party and the petitioner, which caused the petitioner, who was the plaintiff in the original suit, in not taking any steps in the suit, which caused the suit to be dismissed for default. On scrutiny of record, it appears that this learned advocate for the plaintiff, so there is no communication with the learned advocate for the plaintiff. But for this wrong recording, my lord, I cannot.
What is this?
Sir,
What is this communication?
May I just indicate, your lordship, this page 42, your lordship, has been given it to me. Now, what here happened, your lordship, this particular letter, when he has given, he has only forwarded me the check. If your lordship sees, there is no mention that my
that I've seen. This the learned trial judge has recorded on scrutiny of the records. It appears that this learned advocate for the plaintiff has not taken any steps and also not intimated the court that prior there to the paragraph, primarily according to the petitioner, there was a letter of communication between the learned advocate and the petitioner, which caused the petitioner, who was the plaintiff in the original suit, in not taking steps, which caused the suit to be dismissed. Where is this letter of communication?
No, lordship, there is the letter of communication is page 42. There is only one letter of communication.
That is by the opposite party to the petitioner.
Between parties.
No,
between parties.
Yes, your lordship, it was from the defendant to the plaintiff.
Yes.
Yes. Now, your lordship, this primarily according to the petitioner, there was a letter communication between the learned advocate and the petitioner, which caused the petitioner was the plaintiff in the original seat in taking the suit.
Does not make any sense.
No, does not make. But thereafter, your lordship, is on scrutiny of the record, it appears that the learned advocate for the plaintiff has not taken any steps on behalf of the plaintiff for a prolonged period. This is nothing to do with the earlier paragraph.
This learned advocate.
Please. Now, prolonged period, and also not intimated the court, that he tried to communicate with his client, despite which the client, that is plaintiff number 2, did not contact him to give instruction regarding the suit. It is also the duty of the advocate.
Where is that? Where is those records? Where from the learned trial judge is coming to this finding?
That's, your lordship, can only be found before the trial court. He has seen those particular records and then found it. He has said, your lordship, that
there are the previous orders.
Communications.
What are the previous orders?
That has also not been annexed, your lordship, with them.
You also don't have that. Yes, you are having those previous orders.
Let me inquire, my lord. Achha.
Please bring those orders, Ashwin. Heard the learned advocates for the parties. So the learned advocate appealing for the petitioner.
Do not proceed with this.
Let it proceed, nothing will happen.
Then, my lord,
If it is section 5 is dismissed, everything will be dismissed. Let the discuss proceed to some extent.
Section only one thing.
Order 9, rule 9.
Section 5, if it is dismissed, everything will go.
Same order in 28 also, my lord.
Same order in 28, same recording.
Same
recording.
absolutely same recording.
28, same order. You are appearing.
I'm appearing.
Yes, next.
Great.
28, the same order. Yes, call the next matter.
টা কি হলো
25.
A suit for partition. I'm the defendant. No matter the suit property is the residential house. No matter I filed an application for repair, but it's admitted from the plaint that I'm in possession of the entire house. And 2-room house, entire house I'm in possession.
You are defendant.
I'm the defendant. Now I filed an application for repair, which has been rejected by the London trial court only on the ground since the application was pending since 2022. The application is now become redundant. Nothing will. There is no such urgency. But kindly see order number 19.
19 or 91?
Order number 91.
Mr. Ghosh, you have not filed any.
But if I kindly see my application.
What?
The repairing application. In my application, I have categorically said, if you also kindly see my application.
You have not filed any local inspection.
Well, kindly see my only once my
Page?
application. Page 70.
17.
17. Kindly come to page 18, the second paragraph.
Page 18.
18. The second page. The fourth line from the top starts with, in view of such circumstances, it has become urgent need to repair the suit premises. In that event, the instant defendant undertake to file local inspection if necessary. No, I have not given any opportunity, but only on the ground.
What opportunity? You have to, Mr. Ghosh, for the purpose of deciding an application for repairing, those materials are to be before. So that will be allowed first, then local inspection.
Kindly consider that was not the reason for the rejection.
I'm supplying the reasons, Mr.
That they may kindly liberty to file an application to that effect, because the rainy season is going on. And if you will also kindly see, I have annexed the entire orders from the date of filing of my application and till the date of hearing of my application.
No caveat is there. What can be done?
But kindly dispose of this revisional application with the liberty to file a prepared application with the London trial. Because what is required, where the rainy season is going on. And only on the ground, the application is filed on the year 2022, and I came before this honor before the London trial court for hearing in 2025. And admittedly in the plaint, it says that
No, where is that?
If you also
That is
calculate the-
not the ground for rejection. Rejection ground is that you have produced.
No, but if you also
and
calculate
there's
the last
also no-
factor, after about 2.5 years, the petition showing urgency for repair in the premises as stated by the defendant number 1 and 2 Injunction.
Mr. Ghosh, I have to
Moreover,
say-
the photograph has even not identified the premises, neither does it bear the date of the picture taken. The photograph cannot be relied on.
Maybe a lot. বলতে হবে না বলে কথা হবে না। Maybe a lot.
ওটা লিখে দিয়েছেন তো টাইটেল স্যুট স্যুটটা স্টে থাকবে না ওটা বলে দিন
The tenant before losses. But a suit has been
tenant is
tenant.
before
But I am tenant. Suit has been decreed. Eviction suit. I prefer an appeal. I find an application for stay. Kindly say impugned order.
yes occupation charges.
Occupation charge that was rent was 1,600 and occupation charge is fixed 10,000.
1,600 to 10,000.
Yes. 1,600.
You are lucky, Mr. Bhattacharya.
I'm lucky. Can you see the order?
My 18,000 was made 1,80,000.
What here?
18,000 was made 1,80,000.
Asbestos, two asbestos. Can you see? I have to give you the picture of the room.
Mr. Bhattacharya, don't live in a asbestos shed room. Please move out.
Yeah?
Please move out, get a better accommodation. It's not good to stay in a asbestos shed room in summer. It's very hot. It's very difficult.
But I
Please
know.
fetch. Now it's the rainy season. It's the time to fetch. Please. move out.
Please, your vast experience, my lord, the Aftaram, your lords knows everything. But kindly see the impugned order. Kindly see. Your lords knows vast experience.
Yes.
As simplex also judgment, honorable, that's the justice standard judgment also is there. Your lords knows. I know. But kindly see impugned order.
I do not know anything.
All yes. But inner page 4, the impugned order.
Where is the suit property? Show me the plaint or the decree, whatever it might be.
Horidepur, Noskarpara. Noskarpara, Layas Bosti. Two asbestos room.
What is the market rate of rent in that locality?
But I asked my client 3,000 and 3,000 to 400, 4,000.
So it's readily available. So you can move out. Why are you fighting?
Is it? But I'm sorry,
litigation cost over and above this litigation.
I'm submitting. But she was what is the maid of the landlord. And landlord asked her, yes, to stay here as a tenant. That's the reason. Now the landlord has filed a suit. She is practically remained. It is very impossible. I have seen my lord the condition of the petitioner. And his what has the maid?
Don't say those things because.
But can you see the important? I know that is why I am not bargaining. Kindly see the order.
What are you doing?
But
reducing the occupation charges.
Excessive. Can't you see there is a formula? Where is the reporter stamp paper report? Nothing, no evidence.
What have you produced? What document have you produced to ascertain the market
I have
rate?
not produced.
Then
It's a job. Kindly see the import order. After going through a case record, as well as the stay petition. Nothing else.
Mr. Bhattacharya, is this the room 49? Page 49 is the room.
Page
49?
49.
Yes, yes.
Yes, Mr. Page 49.
Condition is very good.
No, not very good, Mala. If engage any lawyer, you go to the this is the condition. This is total dilapidated condition. For that reason, out of sympathy, you will stay here. Now you file a suit. Now. Okay. That's my humble. Otherwise, it will be very difficult.
What difficult?
Ideological is the important. I have gone through it, nothing else. Oh, the jury have nothing else. Yes, this stay petition, I have gone through it, you do it.
Appeal is fixed for hearing.
Fixed for hearing.
So I'm directing the appeal to be disposed of.
That proceeding with the 200 days of the execution proceeded, the next day, police cost has been also deposited because there is no stay. But if I evicted, that is my submission before lost him. Today was the date for submission police cost. I extend everything I have stated in the petition.
When the decree was passed?
Decree was passed on 22nd February 2023.
2023.
Immediately I pay for an
So according to you, what is the rate of rent?
According to 3,000.
3,000.
3,000. According.
So 3,000 from 2023 till August you pay at that rate. Deposit a lump sum amount. I will state it, and I will direct the appeal to be disposed of by August.
From February 2023. Now I am paying till January. I paid 1,600.
1,600. That 3,000. Calculate
3,000.
Not minus.
3,000. 3,000.
5,000. I'm making it half. 5,000. Deduct 1,600. Balance from 2023. Deposit. I'm directing the appeal to be disposed of by September.
3,000.
That time stay will be there.
3,000 from 2023.
Yes, you are saying market rate.
Yes, I'm saying.
I'm accepting that. So 3,000 to 4,000 you have said. I have said
3,000. I had a talk with my.
So you have, Mr. Bhattacharya, you have said 3,000 to 4,000. I have made 5,000.
I have.
So minus 1,600.
Yes, I agree.
So from 3,000 from 2023, how much it comes? Pay in a lump sum in September, and I will direct the appeal to be disposed of.
I am submitting. I have paid up to I have annexed the rent receipt of Chalan. 1,600. I am
asking you. I'm saying 5,000 minus 1,600.
Now just for inform you the 3,000. Now we are saying
yes. 5,000 minus 1,600 will not be deducted from 3,000.
So that will not be deducted.
No. From 5,000 I will deduct 1,600.
May I submit one thing more? May I submit? This is my up to 2,000.
Even if you are liable to pay from the date of the decree. From the date of the decree till this date, how much it comes, pay at that rate up to September. I will direct the appeal to be disposed of within September.
My client is here.
I'm keeping it tomorrow. I'm keeping it tomorrow. Take instructions, come back. You have to deposit within 1 week.
1 week?
Yes. Where are the parties?
Yeah?
Where are the parties?
Horidepur.
Behala.
Yeah. Horidepur.
Horidepur. Sir, I am keeping it in the next week. What is the date of execution?
Execution. Today they have deposited the cost.
What? So today they have deposited the cost?
No, my client did not get.
So, sir, I am keeping next Tuesday under the heading for orders. Take instructions, come with the money, deposit that unconditional.
No, I shall come back tomorrow. I shall come back tomorrow.
The petitioner is directed. the suit pro-
Lordship, item number 27. Lordship, I appear on behalf of the petitioner. Lordship, item number 27. I appear on behalf of the petitioner. Lordship, this is a matrimonial suit. My matrimonial suit filed in the year 2022.
who is your counterpart in the learned trial judge?
Meaning the advocate, Lordship.
Advocates, respective parties. What is the name of the advocates of the respective parties?
Lordship, I understand, Lordship. Then may I come back tomorrow and
Yes.
did it get to your Lordship? May it retain its possession, Lordship?
Not today, next. Opposite party led by Mr. Rai. Who is for the petitioner?
So however, Chief actually recall the two matters. Another was pleased to be.
Where is he?
Because your lordship was the, that matter your lordship was directed, that undertaking was given by, so that till next date of hearing, no specific meeting.
So, today is not the date of I am only making it not today. I am not passing any orders.
Okay, up to 9, exception.
No, did I say anything up to 9? Where is that order? Yes, Mr. Chatterjee has come. He's for the petitioner.
He's leading me. No. He's leading me.
Where is that order? Item number 75 এ ফাইলটা বার করব এখানে অর্ডার রেকর্ড Today I am adjourning. I am making it only not today. Okay. Mr. Banerjee is available. Where is he?
No. Mr. Parthapati Mukherjee is not coming. He said,
Parthapati Mukherjee, who will argue this matter? Mr. Mukherjee will argue or Mr. Banerjee will argue?
Mr. Banerjee also.
So, where is he?
Which is 10 নম্বর নিয়ে next day.
No. Till the applications proposed to be filed is taken up for hearing.
Yes. That is why.
Taken up for hearing in view of this solution.
Can you extend that? Can you extend?
What? Not today. কিছু করতে হবে না, not today করুন। Nothing will happen. Yes, yes.
Sincerely, we pray before your lordship.
No hearing has been কিছুই করতে হবে না. No hearing has been made. Till the hearing. No hearing is.
You're pressing my application.
This is no hearing has been taken. The interim order is still the. Mr. Chatterjee, you have said you are led by Mr. Rai.
Always, with leave of Mr. Rai, my lord, have told all these matters to be heard together.
Mr. Chatterjee, the difficulty is that there is a resolution.
Mr. Banerjee is here, my learned friend is present.
Mr. Chatterjee, what can be done? Do not. What is your resolution? In the in the absence means in the court, not in.
My learned friend is here. Lord, we are not saying anything.
They are paying for it.
Can you record that? Then that they are paying for time, and can you fixes all these four matters together? And there has been no hearing today. Can you record that? And can you direct all four matters to be heard together?
That direction is already there.
But they are not appearing together.
Mr. Chatterjee, let it remain. No problem. It will be taken up. Let this matter. Ashun. Item number 30, ডাকুন তাড়াতাড়ি. Yes, item number 30, who is appearing? Call করেছেন? Who is appearing? For today next. 31 হয়ে গেছে. 32.
No, I'm for the petition, my lord.
Yes.
This is my prayer for expeditious hearing of the missed case number 33 of 2020 under section 34 of the Arbitration of the and Constitution Act pending before the learned additional district judge first court Howrah, my lord. My lord, fact.
টা দেবেন তো 31 দিয়েছেন. Yes.
And in arbitral proceedings, my lord, award was granted in my favor, challenging the same. Here the my lord opposite party file a my lord, petition under section 34 of the my lord, Arbitration and Conciliation Act, my lord, and I file a non-maintainable application, my lord. Since 2021, that non-maintainable petition has not been, my lord, disposed of.
Application under
Kindly
under Article 220.
33, my lord, I am appearing.
Yes.
This is an application, my lord, against the my lord, order passed for drawing of the electricity connection over the my lord, premises during the pendency of the my lord, my
Which
lord,
is the order and the challenge?
my lord, the order has been challenged, my lord, that the firstly, my lord, that order dated 15th of
May.
15th of May, and thereafter, my lord, it's correction dated 3/6/2025.
You are the plaintiff.
I am the plaintiff.
What is the difficulty?
My lord,
You don't want the electricity connection. What is the suit for?
Suit for, my lord, permanent injunction against the against them. My lord, what they are claiming, my lord, they have filed an application for counterclaim. My lord, counterclaim, they have said that there is a way through our premises, our my lord, land, where I have purchased. My lord will find from the only case is that in the Chauhoddi, my lord, the boundary of the deed, there is a written that there is a cholachole rasta. But my lord, boundary, my lord, my case is that if the boundary is, my lord, is on that score, my lord, it means boundary means outside. My lord knows that the Chauhoddi, my lord, cannot be inside the sold out lands. My lord, Chauhoddi, my lord, has.
Chauhoddi is the boundary demarcation. That will be outside. What are you saying?
No, my lord, bounded by
yes,
bounded by the on the north.
That is the outer limit.
Outer limit.
Yes.
Outer limit. And they are claiming that this way is inside the sold out premises. That is, my lord, the whole difficulty. And what I am, my lord, we are not on that, my lord, that they cannot take the electricity line. My lord, the very adjacent, my lord, will find from the middle portion, the very adjacent premises, my lord, belongs to his father. My lord, he can well take the my lord, there.
From which plot you have taken electricity? Your electricity line goes through which plot?
My lord,
your electricity line goes through which plot?
My lord,
it is owned by you. The entire electricity line
no,
to
no,
your house.
No. This electricity line, my lord, they are trying to.
You are enjoying electricity.
Yes.
So the electricity line is only through your plot, not through any other plot.
Yes, the just next plot, my lord, belongs to the father. They are taking.
I'm asking about your electricity line.
Yes.
Not there.
Yes,
your electricity line is running through which plots?
My lord, from my my lord, the outer my lord limit is my lord, the metallic road. Just against that, my lord, my plot is situated.
How could you take? It's not your plot.
My lord,
it's not your plot. How could you take electricity from there?
My lord, that plot is situated, my lord, behind us. One thing, with a common boundary with his father. With his father, this is the my lord, his father.
Serve a notice. The petition is directed to serve a copy of the
My lord, deeds. My lord, late that I have craved leave.
But my lord, there was a caveat, my lord. We have served the caveat, but the caveat is not appearing.
He's appearing.
Oh, my lord, then my lord.
Yes.
My lord, simplicity prayer, my lord. My lord, if my lord kindly, my lord, there are two wills, my lord. A person died, interstate, issueless. My lord, I'm just giving, my lord, I have lost a caveat.
Yes.
I have lost a caveat, my lord, and I have
lost the caveat.
I
Oh, in that proceedings, yes.
I apologize, my lord.
Yes.
I lost the caveat. My right, I have a caveatable interest in the manner that the person died intestate.
Who are you?
I am also a outsider, the person who
Outsider. So how
may,
do you have caveatable interest?
may I, my lord, maybe the word I'm using is not proper. Now, my lord, what has happened? There are two wills. He did not have any first class heir. Now, my lord, he has bequeathed properties to me by a particular will which was executed in Rajasthan, an unregistered will. I did not apply for probate because under the laws of Rajasthan, probate is not required. Now, my lord, I am in possession with regard. Now, the gentleman came to Kolkata and he started residing herein. With another lady who happens to be a close confidant of her. She also does not, she is neither a first class heir nor a second class heir. Now, she procured a handwritten will where the property handwritten will
very difficult to challenge, Mr. Trivedi.
But not in the handwriting of the testator, not in the handwriting of the testator. I'm because I'll.
So you said
unregistered
handwritten will.
But
very difficult to challenge.
Why I'm not in a framework of mind to do the matter because my law's list says that 3 o'clock my lord will.
All right, then I'm making it not today.
But I'll come tomorrow, Milan.
You should have said that at the beginning. That you are not in that frame of mind.
My lord, I apologize. My predicament is that, my lord, again, whether it will reach tomorrow or not, therefore, so I was getting a chance, my lord.
I have medical appointment.
No, my lord, I have no issue, but my lord, some percent because it will go down in the list.
After tomorrow. All right, let it appear. Ask any of your friends to mention. I will consider.
My lord, I shall mention because.
After 35, yes.
How are you?
I'm for the fine. I'm for the petitioner, my lord. My lord, this is, my lord, a challenge.
That one, no.
No. No,
yes.
My lord, it's a challenge, my lord, to an order.
Any caveat is there?
Yes, you have served the day before yesterday. You have served.
Difficulty. How will you address the learned councils?
In fact,
All-
even the last day, the same thing happened in this court.
All balance.
Both Mr. Banerjees, how we will record in the order?
The better Mr. Banerjee that way, the lesser Banerjee.
Yes.
My lord, this is, my lord, a challenge to, my lord, an order of 22nd,
What is
26th.
the order impugned?
My lord, in arbitration, my lord, we had asked for amendment. Lord, that has not been allowed.
Claim application.
Statement of defense.
Claim application, you have paid for amendment.
No, I'm, my lord, for the respondent there.
Oh, your
In my counterclaim.
counterclaim.
The counter statement, counterclaim. I had given, my lord, certain. I had not particularized the counterclaims. Now, my lord, I had, my lord, then made filed an application for amendment, asking, my lord, for the purpose of.
I do not have any difficulty in taking up.
No,
I've not
no,
seen.
no, my lord. Oh, no. We wouldn't have been here, my lord, if. If, my lord, that was. Then we wouldn't have been here. The amendment would have been allowed.
Then Mr. Banerjee would have come.
Yes, then Mr. Banerjee may have come.
Yes.
My lord, I'll tell my lord, the evidence on behalf of the claimant, my lord, was already done.
Evidence concluded.
Yes, on behalf of the claimant. So, my lord,
Cross also completed.
Cross-examination.
Yes, I am supposed to give chief, then cross.
No. Their cross-examination. Their cross-examination of the claimant's witness also completed. I am supposed to give, my lord, my evidence in chief. Then, my lord, that's when we or rather, my lord, realized that, my lord, perhaps certain further pleadings would be required. Or particulars of pleadings would be required so as to, my lord, support our case. This is, my lord, a case where, my lord, the Sri has, my lord, filed with regard to saying, my lord, this usual finance agreements which are there. My lord, we say it's all, my lord, been done. Outstanding amounts, my lord, are not really, my lord,
given credit.
Credit to. And we also, my lord, we need to give some particulars to similar. In fact, we made overpayments.
What is the ground of rejection?
Ground of rejection, my lord, is actually Order 6, Rule 17.
Proviso.
Proviso. But, my lord, in the Arbitration Act, that's not what applies. So, in Order 6, Rule 17, it says, my lord, if entire evidence is, if the trial has started, if, my lord,
That is not an absolute embargo.
it's not an absolute embargo. It's not an absolute embargo. And, my lord, with just two things, my lord, looks at, my lord, Order 6, Rule 17 first. But otherwise, my lord, it is permitted. Even, my lord,
but
something
there are some amendments, not all amendments.
Not all, but very rare, my lord. At least, my lord, rejection of amendments and
Otherwise, the purpose of an object of proviso would be rendered.
But, my lord, kindly look at this. Court may at any stage of the proceeding allow either. Sorry, my lord.
No, you are on the Civil Procedure Code.
I'm just showing, my lord, this is not, my lord, what is, my lord, there in, my lord, the Arbitration Act.
No, what are you saying?
My lord, I was showing the Civil Procedure Code. My lord has the Arbitration Act. That is also. Can you, my lord, then look at the Arbitration Act first?
Yes.
23. 3. Unless otherwise agreed by the parties, either party may amend or supplement this claim or defense during the course of the arbitral proceedings. 23(3), my lord.
Applicability of the Civil Procedure Code, any provision is there?
Section 19.
19.
19.
Shall not be bound by the Code of Civil Procedure.
So 23(3), my lord, the principle is not really restricted by that. Of course, my lord, I'm not saying, my lord, it will be endless and, my lord, not, my lord.
Where is the impugned order? Take me to the impugned
Yes,
order.
my lord, kindly come to, my lord, page.
Which volume?
My lord, first volume, page 32.
It's 35 no, we have 6 Rule 17 over 35.
33 at the bottom, my lord, you'll find view of the above application amendment now taken up for consideration. 34, my lord. In the middle, my lord, will find. According to this, in the middle, my lord, according to this contention, respondent totally failed to make out a case that the prayer for proposal comes within the purview of proviso of Order 6, Rule 70 CDG as contained primary object to respond delay the present application. Yes, contained and such. And paragraph 14.
It's only on proviso. Merits were not considered.
According to us, my lord, at page 36, my lord, we'll see admittedly just before paragraph 16. Admittedly, the prayer for amendment has been made after conclusion of the evidence of the claimant.
No, merits were also considered. It says
920. No, my lord, only on the proviso that we have not made out. The belated state because, my lord, evidence has started. Paragraph 17, my lord, can have a look.
But paragraph 20, if you come, Mr. Banerjee.
Yes, my lord, 20. In view of the above facts, and can be safely held that the application is devoid of merits, liable to be rejected. Decisions cited by
This on Order 6 Rule 17.
respondents have no manner of application consumer present fact.
So Order 6 Rule 17.
Right.
Basically on proviso.
my lord, what it appears, my lord, it's really, my lord, the learned judge only looked at, my lord, the proviso, saying that because we have not exercised due diligence, could not raise the matter before the trial commenced. Well, that's paragraph 17.
Mr. Banerjee, are you
Lord,
not
Maintainability firstly will become
maintainability of
an application. That also I heard.
why?
I tell you what. So judgment, not every order that is passed by an arbitrator, because the arbitrator is not procedure, and matters that are covered under the Arbitration Act, 27 are entertained rarest of rare. I'll show you. I will be aware of that, but I'll cite those forms. And
I also have
I'll
that.
show something this has been going on from April 2023.
No, Mr. Banerjee, two things. One is this basically on proviso, not on merits. So one thing you may say that unless they cross the proviso, court cannot enter into the merits. That's one part.
Not that. I never refer 23 of the arbitration.
23.3, yes.
Unless otherwise agreed by the party. Sorry.
Yes.
Either party may amend or supplement this claim, but depends during the arbitral proceeding, unless the arbitral tribunal considers it inappropriate to allow the amendment or supplement having regard to the delay making. If I place the impugned order, your lordship will see that from April 2023, this has been going on. My SOC was filed on 9th of June 2023.
So according to you, this is more harsh than the proviso to order 670.
And this discretion under, so I am very grateful, Lord, and this discretion is an exercise of jurisdiction for the tribunal. This can be assailed only in 34. Because every order passed by a tribunal cannot be assailed under 227.
Mr. Banerjee, yes. I
34.
No, I will come to you. Only thing is that you are very right that those are the line of decisions which says not every order has to be challenged, can be challenged. Section 34 is a ground. Now that was also the ground when the civil procedure code was amended, and there was an amendment to section 115 also and 115A also. That was the similar object, because why it was amended, saying that unnecessarily under 115 interference is made, so it is ultimately delaying the disposal of the suit. That's the object for amendment of section 115. But the question is, let us assume that yes, challenge is not accepted now. Mr. Banerjee is relegated to not now. If you have anything, you can finally in 34. And 34, court finds, yes, this was not.
Whole thing will.
So now again, starting de novo. So that's the argument, Mr. Banerjee, was why 227 will be, even that it's rarest of rare cases.
So I will show this analogy that your lordship has rightly given is the analogy of the Supreme Court. Saying
all right. So no, I was only inquiring from you that it's mainly on the ground of delay, not on the merits. All right. So now I will come back to you. No, I was only trying to ascertain that if your submission is that also on merits, then it's another thing. Then, Mr. Banerjee, I did not go into the merits. You have to satisfy that even with this delay, the court cannot reject on the ground of delay.
But I have not started my case yet. The respondent has not started his defense yet. The delay has to be, my lord, apropos the whole arbitration. The learned arbitrator has, my lord, only considered.
And only one thing.
And look at, my lord, civil procedure code, my lord.
I'm coming. Please come to 23.3.1. 23.3.1.
Yes.
Please see, unless otherwise agreed by the parties. What's the agreement? Any agreement is there with regard to this amendment. So there is no bar with regard to the.
No. There's no bar with regard to that.
So parties have not agreed that no, we will not amend.
It's the tribunal's prerogative or the tribunal's jurisdiction to deal with it. Now, if kindly looks at Order 6, Rule 17.
Yes.
can you see what has been considered by the learned arbitral tribunal?
Arbitral tribunal has considered Order 6 Rule 17.
Yes, now Order 6 Rule 17, my lord, it starts with provided no application for amendment should be allowed after the trial has commenced.
Yes, trial has commenced.
Yes, but this is not applicable here. So
That is
the
a
delay
different
has to be,
thing.
my lord, in perspective of, it's not, my lord, more strict than, my lord, what fell from, my lord, I'm sorry, my lord, I'm joining, my lord. It
Yes,
is
yes.
more strict. It is not more strict. It is more liberal. Because the purpose of the arbitration is, my lord, also, my lord, bring to an end whatever, my lord, the disputes are between the parties. I've asked for an amendment which will now enable me to particularize my defense. I've already given the defense. Otherwise, my lord, without these particulars, I have also given evidence on that. What happened, my lord, the affidavit evidence has all this, my lord, particulars with regard to, my lord, my case.
That you have to give, provided you are allowed to.
Correct.
Provided
Correct.
you are allowed
Because
to.
I know, my lord, a point will be taken. Oh, sorry, look, it's not there in your pleadings.
No,
That's the difficulty I'll be
there are two aspects. One is there is foundational basis in your original pleadings.
Yes.
You are trying to elaborate or amplify those.
Yes.
That's
Yes.
one aspect.
Yes.
Whether you are trying to make out a new case,
Correct.
make out a new relief, which you cannot, maybe because it's become barred by law of the limitation.
Even limitation, my lord, has seen, my lord, the Supreme Court decision, my lord, on the question of amendment. It says that also really it should go allow the at the time of final.
Which decision? Life Insurance Corporation.
Yes, my lord,
Justice Pardiwala's judgment.
Yes, 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 yes.
Justice Pardiwala's judgment, paragraph 71.
Yes, now,
Paragraph 71, it says if it is expressly barred by limitation, Mr.
Express.
Yes.
Express.
Yes. There are two things. Limitation is a mixed question of law and fact.
So far as, my lord, amendment is concerned, I have found it very difficult, my lord, to already anywhere to oppose amendment, particularly in arbitration. I've seen, my lord, amendments happening even, my lord, after cross examination is over of the, my lord, the respondent also. At least I found it, my lord, very difficult to oppose. But anyway, my lord, quite naturally, my lord, everyone, my lord, takes a, my lord, viewpoint. So what I'm saying is, my lord, here the consideration was only because trial has commenced. But so far as section 23(3) is concerned, it's not trial has commenced.
According to you, there is no bar.
That's right.
It may be delay, maybe prior to commencement of trial also.
Correct. Correct. It may be before, it may be after.
Any point of
Any
time.
point of time.
It's only the delay,
Yes.
not the trial commencement.
Not the trial commencement. Because in the civil procedure code, it seems the trial commencing, then you have to show your exercise due diligence and other things like that. Because the language is provided no application for amendment shall be allowed.
Yes.
After the trial has commenced, unless the court comes to the conclusion.
Yes.
So it's totally, my lord, a different test. Unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matters before the commencement of trial. Which means you had knowledge of all this, you could not raise it. But, my lord, that is not, my lord, the restriction, my lord, in the Arbitration Act. Because Arbitration Act, my lord, knows it's a question of, my lord, really natural justice being followed. So today, if he is given an opportunity, put me to cause. If there was a question of saying, no, I have put me to cause, whichever way. There may be 2 extra sittings of arbitration, 3 extra sittings of arbitration. That's right. Well, anyway, my lord, the extension now, my lord, is up to, my lord, another 1 year. But that's, my lord, a different issue. That's different.
That is also one of the ground, Mr. Banerjee. This mandate.
No, so, my lord, it's a question of,
fixed.
my lord, it's a question of having, my lord, 2 or 3 more sittings. But what I'm saying to shut me out is to permanently shut me out.
Extension, Mr. Banerjee, is also not a matter of right. It's
No.
court whether will grant extension of that or not.
Now that extension is already there.
No, that's there.
It's there. What I'm saying is, my lord, the delay has to be taken its perspective to the arbitration itself. It is possible, my lord, sometimes, my lord, engineering contracts, my lord, detailed engineering contracts, or, my lord, detailed, my lord, things have to be given.
What is the nature of the amendment?
Will kindly
please show me that. Because you have also sought to incorporate some reliefs, additional reliefs also.
Yes, yes. One of the
counter claims is already there.
First, my lord, kindly see.
It's already there is.
There is a counterclaim. No. The figures are not there. My learned friends correct. The figures are not there.
Where is the original counterclaim?
Yes, my lord, kindly come to. My lord, the original, my lord, is at page 320 to 336.
Which volume? That's difficult. Mr. Banerjee, why is this is the volume? What have you annexed here?
All the pleadings
Just
are next. Because my lord asked for the.
Dasgupta my lord wanted all pleadings to be there.
Why? Are pleadings? No, this only the claim application. Your and the application and the written objection. If these are the only four. Page
320, my lord.
Yes. This is the original counterclaim.
This is one of the original counterclaim.
Statement of defense with counterclaim.
Yes. Yes.
Which paragraph counterclaim starts? No, Mr. Banerjee, there is no relief claim. You have only said rejecting the statement of claim and impose exemplary costs. Further awards in favor of the
further awards in favor of which they intend to as per law.
So, but you have not claimed any effective.
No claim. That's what I said. The quantification was never there.
Where is the supporting pleadings with regard to other claims?
21.
Kindly look at
does not owe any money towards
paragraphs 20. State against you on 2021. This is all I have. I can't.
Mr. Banerjee, one query to you.
Yes.
Whether the cause of action of the counterclaim is prior to the filing of the defense or after that?
So it will be before.
It has to.
It will be prior.
After?
No. Prior to the defense.
Prior to the submitting the defense?
Yes.
Cause of action?
Yes.
Show me from your amendment application.
Yes.
Because Mr. Banerjee is nodding his head saying no. That Mr. It's prior.
I can't.
It's prior.
It's prior. It's prior.
I mean, evidence দিয়েছি.
No, I was thinking he was nodding his head. He was saying that no.
তুমি evidence.
Yes.
Evidence দেখো.
On right matters, he doesn't disagree with. So I was hoping he will not also disagree when I ask for amendment.
Yes.
349.
Where is the amendment application?
Yes, that is that page.
আচ্ছা 349 এভিডেন্স টা দেখাও তারপর যাব এমন
349 the
এভিডেন্স
আরে আগে তুমি
অ্যাপ্লিকেশন হচ্ছে তোমার এই অ্যাপ্লিকেশন হচ্ছে 430
349
349 is the
chief.
That's the exam.
So this is the chief. No, where is the amendment application?
430.
That's at 430.
430 আর proposed amendment হচ্ছে 507.
ছোট্ট দিয়েছে।
হ্যাঁ এই চারটাই তো কপি পেস্ট করেছি। This is the same chart.
430 is the application for amendment.
Page para 5. Para 4, para 5. This is a part of the evidence. এখানে কিছু বেশি পেমেন্ট করেছে।
These accounts, most of the parties don't know what is happening to the.
What is the relief which you are seeking in by way of counterclaim?
সেটা প্রপোজ করতে
507.
507.
I'm sorry.
Amended is 537. 537. Volume 5. Volume 5. 537.
And in the application we have said, no formal application made, but.
No. In the application for amendment,
yes.
Where is the relief claim you have said?
It is at 537. I've annexed the amended copy of the counterclaim.
What's the dispute in the arbitration?
Well, the dispute is, I'll tell my lord. Well, there was a master facility agreement, which was given. Of 2019.
January 2019.
They say, payments have not been made by us under the master facility agreement. We say, payment has been made, credit has not been given. And there were assets which were lying there with them. They, as security, they have sold the assets.
They have not given credit.
When they have sold the assets.
They have not disclosed. We have made an application. We have made an application.
They are not disclosed.
We have made an application for account. It's lying.
When you came to know about that, they have disposed the assets.
Yes. Our application.
Our application will come 339. 339. In fact, we asked, this is all generally done at the instance of the financier. There are a lot of issues involved in this arbitration also, including the institution of the arbitration itself. Because we know Shrey went into insolvency. And during that period, where the administrator was there, one of the directors have signed the statement of claim.
Para 3. Para 3 and 4.
Because we did not have all the documents with regard to what is happening.
Totally in dark.
Yes.
Now we have in the original counter statement, will find we have sought to make a case with regard to that no amount is due. And we have denied the accounts which they give. Now we have also tried to now particularize by saying that, look, you have not given us accounts. So the amounts which you have, the possession of the assets which you had, that has also been sold. So counterclaim arises out of that also. Saying, whatever with regard to these, they always the constituent is always in the dark as to what is happening. Judgment. So my only submission is that the amendment, unless it's no, that's unless it really.
Mr. Banerjee, these underlined portions, these are the portions which you want to add.
Yes. That's 537.
537.
Onwards.
507.
It starts from 526.
526, paragraph 28.
Correct.
This is a part of evidence. Chief to dekhiye da.
Because this is आगे तो pleading stuff है
not the case.
These are now all part of evidence, but we can't get this.
Chief को देखिए ना.
So we have said no amount is due. Now we have given the particulars in page 527 with regard to how 528 how this repayment has been done. They have to deal with it and say that yes, either done or not done.
You have annexed to chartered accountant certificate. Says that payment has.
And in the evidence now in support of original counterclaim also we have given all these details with a chartered accountant certificate. So it's a question of dealing with it.
They will have to recall their witness again. They have to file a written statement against this. They have to recall their witnesses.
All that is.
Mr. Banerjee, if you are entitled to a separate proceedings is not a bar.
No, it will be.
Why?
Because this arises out of the same transaction.
Same contract.
It will be conclusive. If I am not able to bring all this, then whatever I suffered, if I suffer an award, that will be conclusive. This is my answer to their claim against me of the master facility agreement.
Question would be, everything will be so. They will have to file a written statement. They will have to recall their against this. They will have to recall their witnesses.
That is in any amendment that happens. In any amendment.
That is why this stage delay is a factor.
Yes,
that's the reason, Mr. Banerjee, to carve that. Because that is the object of proviso also. You may say no, proviso may not apply. That is why prior to commencement of trial, exceptional cases after commencement of trial.
But my lord, here I'm saying, my lord, that absolute bar is not there firstly. And the delay has to be, my lord, relative to, my lord, what is happening here. I have come with my defense. I, my lord, given an affidavit evidence.
What is your explanation for the delay?
My lord, the delay, I've said, my lord, I was not.
That you have to explain.
I have explained. My lord, kindly
Show me
look at-
your explanation of the delay.
My lord,
Page
page, my lord, 430, my lord, the application is there.
430.
11. My lord, paragraph 9, 10, my lord, with regard to, my lord, that not being allowed, my lord, then all that happened. Then, my lord, 11.
No, these are all facts. Where is your explanation for the
11,
delay?
my lord, 11.
Why have you paragraph 11?
12.
So
Page
11,
59.
12 we have said those are
Yeah,
necessary. But why this delay? How do you explain the delay?
Applicants, my lord, 12, applicant made out every, my lord, then 13, my lord, is the only, my lord, I find, my lord, this is the only, my lord, averment which has been made. Applicant states
So
that-
this is restraint by sufficient cause which restraint the said applicants.
Yes, sir.
That's very vague. Why, when you came to know of this, what is the reasons for approaching at such a belated stage? You have to explain.
My lord, 13, 14, 15, my lord, this is all we have, my lord. In the application, my lord, this is all we have. I can't, my lord.
13, 14, 14.
13, 14, 15, my lord, is all we have. Because this is exactly, my lord, 14 is absolutely, my lord, what really happened.
And Mr. Banerjee, your application proceeded on the basis of the proviso.
It has also, my lord, said so.
Paragraph
But that's
17.
not correct.
But
Correct.
that's your application.
Correct.
That's your application. So court also, the
My lord, I should
tribunal also proceeded on the basis
I
of that.
should the act. My lord, that's not a restriction. That's not a restriction. It has to be, my lord, only delay. I'm not.
But
Section
23(3) subject to correction was not argued there before the tribunal.
Perhaps, my lord.
Subject
Perhaps,
to
my
the
lord,
reading of the order does not appear that you have raised. That is not order 6 rule 17 proviso, but 23(3). That's not the submission before the tribunal.
I wasn't there.
I was there, he was there. 18 judgments were cited by this petitioner on order 6 rule 17 only.
No,
Because the tribunal can't come to defend itself, it's not, it's my duty.
No, I'm also saying I wasn't there. So, my lord,
The recording in the order reflects
it
that.
appears so. My lord, it appears so. My lord,
Reflects
appears, my lord.
that.
My lord, let us assume, my lord, order 6, rule 17 was only argued. But I'm showing, my lord, section 23(3) is, my lord, really, my lord, the ground, my lord, governing, my lord, the question of amendment. My lord, I am also showing, my lord, that amendment is generally, my lord, as I understand, my lord, that judgment is also there, which my lord already knows, my lord, I don't need to, my lord, that amendment is generally allowed. So as because that's the end of, if you don't allow an amendment, these facts will never be tried then. I may have a bad case, I may have good case. If I have a bad case, it will be rejected. But if I have a good case, then that stands, my lord, disallowed forever. That's the difficulty. That is why, my lord, courts have been, my lord, liberal, or, my lord, even arbitration has seen, my lord, liberal to say, okay, let me allow amendment, then we'll see what's happened. Today, allowing the amendment doesn't mean, my lord, allowing my case. He will have to come and say, what I've
You
said.
have to prove your case.
Yes. If what I've said is incorrect, he will say it is all incorrect. You impose costs on me so that, my lord, he is compensated so far as, my lord, if he has to, my lord, file a counter statement, my lord, or, my lord, a written statement to this, or, my lord, he has to recall his witness, whatever expenses are there, my lord, will be on me. Because I have also, my lord, done that, my lord, that taken that chance of, my lord, now coming and saying that this is, but shutting me out, my lord, from my defense will, my lord, a very strong case will be required, my lord, on his side. To say that, no, look, you should not allow that at all. So we are not at the last moment. My lord, my witness is yet to come. He is yet to cross-examine my witness. In fact, I have to prove my case. He would not have put, my lord, this case, my lord, in his evidence. So this is my case. He will have, my lord, ample opportunity, my lord, to cross-examine my witness, my lord, which has not yet happened. So today, my lord, he can just ask 3 questions and say, where is the proof? Where is the proof? And that's the end of the matter. If I'm not able to prove it. So it's not that, my lord, he will also need to, I'm sure, my lord, he will be better advised, my lord, whether he needs to recall his witness to come and disprove my case. So that's not how the principle.
Because once it is allowed, he has to give given a chance to file a written statement.
My lord, I'm not. But, my lord, if it is my case, the law is I will only have to prove.
Yes, but You must be
I
given an
will prove it.
opportunity to controvert that.
He will, of course, my lord, also be, my lord, entitled
Because
to.
this will be your plaint.
Yes.
So he will have to be given an opportunity
Yes,
to
yes,
file a defense.
Opportunity. What I'm saying is, my lord, he doesn't have to prove my case.
No, no.
Cross-examination, my lord, will really be of my witness.
But he will,
Who will come to?
he will disprove your case.
My lord, you don't need to disprove the case.
Once you are trying to prove that.
What I'm saying is, my lord, the procedural difficulties are not
anything
surmountable.
You want to cite anything more on
Lord,
that?
I just want to show, my lord, that may amendment in main matter. Lord, I am not, my lord, citing any cases. My lord, we had got those cases on
Any
the question
decision on section 23 subsection 3?
My lord, not really. My lord, I asked, my lord, Mr. Raj to look for it. One decision we have, of course, my lord, saying, my lord, 23(3) for the 34 amendment. It doesn't come, my lord, under
it's a test under 23(3).
34.
What is the test under 23(3)?
My lord, I can have a. I haven't, my lord, found, my lord, in case. So I haven't looked, my lord, at least, my lord, on the question of, my lord, judgments.
Yes, which decision you want?
My lord, this is only, my lord, that. This is, my lord, is aware of, my lord, this judgment. My lord, this is 2022-16 Supreme Court cases, page 1.
Okay, para 18, 22, 23. Para 18.
Paragraph 71 is the conclusion.
18, 22, 23.
Yes, my lord, 71 is, my lord, the conclusion.
71, the conclusion.
Conclusion is there. But discussion, my lord, are there, my lord, in paragraphs.
Yes, the ultimate conclusion is there.
Yes, 18, 22, 23, 25, 26, and 34. My lord, absolutely correct. My lord, final conclusion is.
They have not been given a copy.
Get a copy down now.
What?
The judgment is
You are aware of it all.
This is the reported judgment. It's in
16 Supreme Court cases, page 1.
আমার ভেতরে একে তো ঢুকে গেছে কথা
Correct, my lord, this is the conclusion. Discussion is also there. And the discussion, my lord.
So you are relying upon paragraph 71.3.1 and 71.3.2.
Yes.
71.5.
Correct. 71.3.1.
3.2, 71.5.
Yes.
71.9.
71.6 also. Aid in rendering a more satisfactory decision.
And 71.9.
And more 71. Yes.
So these are the paragraphs, the conclusions which you are trying to rely upon.
And Malad also 71.8 Malad will see Malad where material particulars are not there.
This may not be relevant. This is not absence of material particulars in the plaint. That's everything you have pleaded, but only particulars. Here you are trying to make out a new case.
Malad, we say nothing is payable. Malad is correct. I won't Malad dispute on
So
that. But
71.8 may not be applicable to your case.
Payment details are also given Malad in the.
Yes, so you are trying to make out the entire case. It's not that you have said, yes, this is the payment, particular 71.8.
Na counter statement. Chief er kotha hocche na. Malad, Mr. Dashgupta Malad is our impression Malad since we have given the evidence. Malad, that, but I Malad not on that. Malad, I'm saying Malad that the fact of some of the defense is raised in my counter statement. Now Malad, I've given also further particulars with regard to Malad that defense.
All right. Anything more?
No, Malad, this is Malad. And Malad has seen 71.9, 70, 1.
Yes, 71.9 it told you.
71.11 also, Malad, I think.
So this is on order 6, rule 17, commencement of trial. You are not on that. According to you, 23.3.
No, Malad, even with that proviso also, Malad, this is what the court says.
Yes, no, it says before commencement of trial, it should be very liberal. Your case is not before commencement of trial. So 71.11 will not help you.
71.9.
71.9 is on delay.
Yes.
Anything more?
Malad, no, Malad, I think Malad, the rest of the paragraphs were marked are all Malad on the. 26 and 34 ঠিক আছে ওখানে সব সামারাইজ করা হয়েছে
Conclusions have been summarized.
yes yes
When it can be allowed, when it cannot be allowed.
correct it helps my lord us my lord I have my lord also decisions my lord to say this is maintainable but I'm not citing them my lord
What is maintainable?
my lord that 227 my lord is maintainable there's no other my lord way
You can cite because Mr. Banerjee will be on that. He says that, but because he will be taking that, or if you want, you can
I will
cite
not
that in
yes.
reply also. That's your choice.
I'll reply my lord I'll sign let me show my lord because every judgment he shows will say 227 is maintainable except my lord and it gives the cause as well when my lord it is maintainable
May I, my lord? Kindly have a look at this. We prepared a list of dates.
my lord I'll just take my lord's leave of 5 minutes my lord the division matters going on this
On the ground of delay,
Just have a look at it.
have you given a copy to Mr. Banerjee?
Yeah, list of dates.
list of dates
List of dates. This is set out in the award also, but I will give a copy. Here,
Set out in the,
I'm sorry, Miller.
set out in the
The certain important dates are mentioned in the impugned order also. But
impugned order.
what are you doing? Miller, please have a look at just 5 or 6 dates. Not 4th April 2023. Your Lordship has seen the ground or the reason. There is no reason why he's come so belatedly. 4th April 2023, Section 11, first sitting on 23rd April. 9 June 2023, SOC files.
What is SOC?
Sorry, not statement of claim. Sorry, not forgive my abbreviation.
This is statement of claim.
Statement of claim file. I'm very sorry, Miller. This was prepared.
No.
19th August.
This is statement of defense.
Yes, Miller. 19th August 2023, statement of defense file. You know, this is what they seek to amend in 2025.
So, Banerjee, these are the usual expressions which are used in tribunal.
SOC, SOD. But in court, we normally don't use abbreviations. My apology. Full things should have been there.
Yes.
26 September 2023, rejoinder file pleading complete, direction to parties to complete inspection by 10th of October. 12th October 23 to 24th January 2024. 5th minutes, 6th, 7th. We give suggested issues 8, 9, 10th, 11th. Respondent did not comply with the direction of the tribunal to complete inspection and discovery. Claimants had tried to reach out to them each time, recorded in all the minutes. And if I show these minutes, your Lordship will find that the conduct of this petitioner is being, what used to happen, lawyers would come and go. If I'm not mistaken, 3 sets of lawyers have changed during this reference. One would come, somebody used to come from Hyderabad, somebody used to appear from the car, because all these sittings I have personally appeared. And every time they would come and tell the tribunal, give me some more time. And she would, because of section 18 of the Act, natural justice, give that time despite my opposition. Please carry on, Miller. 7th of February 2024, issues are framed. Claimant had sent suggested issues, respondent did not give suggested issues. Claimant directed to file affidavit of evidence. Please, I'm very sorry. Hey, abbreviation kyun hota hai? Yes. And for conduct of witness action on 1st of April 2024. 1st April 2024, we sought adjournment. 9th April, amendment to, I filed an amendment to statement of claim application filed by claimant. Respondent sent soft copy, disregards it. 15th April is when my amendment to the statement of claim was heard. And it was rejected on their ground that I was doing this belatedly. My statement of claim was 20th of May 2024. It was rejected because the trial, this SOC, a statement of claim, was filed in June. I was making an amendment in May. It was rejected on that ground. 31st April, July 2024, my affidavit of evidence filed by the claimant.
Yes. Now, you did not challenge your rejection of amendment.
No, did not challenge my rejection of amendment. Because that amendment was such that in law I'll probably be able to get it. I'll tell you, Lordship, what had happened. When they filed the statement of defense, we found this was an unregistered partnership. And certain partners were not there. And the loan agreement that was signed, by then they had come and filed the statement of defense admitting to the loan, admitting to have received the entire part payments, and admitting that payments were not made to me.
which is why this thing is now coming in.
To withdraw those.
To withdraw those and bringing a statement of a counterclaim to something that was filed on 12th of August 2023 without any reason. Your Lordship has seen, my lord, and I'll show judgments that this is not good enough. With all my respect to the petitioner here, after all, you're before a tribunal, there's some element of, and my lord, you come and tell this court that tribunal did not consider section 23(3). 2 days of arguments only on 617 and 617 proviso. Well, my duty is higher because the tribunal doesn't come to defend itself. You show the sitting judge, I'm sorry, show the tribunal that this is what the matter is, and she considers this. 22nd minutes, 19th of August, 24th minutes, 20th of August 2024, my cross-examination is concluded. Evidence of the claimant is closed. 20th August 2024, respondent directed to file, this petitioner directed to file his affidavit of evidence by 6th of September 2024. Then 11th to 25th, 25th and 26th adjournment sought by respondent to file their affidavit of evidence. Then I file an application for re-examination. This application for re-examination is rejected on 18th October 2020.
CW is claimant witness.
My witness. My lord, this date your lordship will kindly recall, 18th of October 2024.
18th
of October 2024.
18th of October 2024, yes.
My re-examination is refused because the respondent appears before the tribunal and argues that a witness is not entitled to be recalled. Whatever is the evidence is the evidence. I can't improve upon that. I'm not on the quality of the order. I'm on the point that the respondent in the reference was fully aware of its rights and the procedure. Because the pleading is that respondent did not know anything. I could not speak English. Then your lordship will see one more aspect. 11th of November 2024, affidavit of evidence filed by the respondent. Witness does not appear due to his illness. 11th December 2024, respondent filed an application challenging the jurisdiction of the tribunal. 19 January, hearing of the respondent application challenging the jurisdiction. Respondent asked for an adjournment, rejected. Tribunal decided to hear this application at the time of final argument. 32nd minutes, 33rd minutes, 6 February 2025. Evidence of respondent closed. Adjournment by respondent.
Evidence of respondent closed.
Because he stopped appearing. He again came and asked for, if I show your lordship these minutes, in fact, I can show page 127 if your lordship sees, just the conduct. The learned tribunal, if I may use the term, was exasperated. I'll show the minutes, appear in page 127. She had to remark about the conduct, about how the respondent had delayed the entire thing and derailed the reference.
Yes.
And I'll show one from Supreme Court judgment that this is a consideration that can weigh on the tribunal because arbitration is a time-bound mechanism, what has just fallen from your lordship. So tribunal has to consider, in fact, when it comes to a 227 court, 227 court also needs to consider that it is a time-bound mechanism, what your lordship had opined when Senior Mr. Banerjee was addressing the bench. Then that was closed. Then they filed a recalling application on 13th of February 2025. Recalling application, then this order of rejecting the tribunal, the jurisdiction.
So recalling was allowed and examination was fixed.
Examination was fixed. And examination 13th
What is RW1?
I'm sorry, Milan.
RW1 examination.
Respondent witness 1.
Respondent witness.
So that I'll give a better.
No. All right. Yes. Yes.
Now, RW1 examination fixed on 13th March. Because I was there, Mr. Banerjee was there, so was Mr. Dasgupta. The witness is sitting there. That date, 13th March 2025, this application is filed seeking an amendment to the statement of defense to bring in a counterclaim that was filed on 12th of August 2023. Now, and I'll indicate, my lord, why your lordship's first query was so important. 23, unlike 617, which makes a distinction between trial and no trial,
There is only delay.
Only delay. Only delay is the consideration. And again, that delay has to be explained. If your lordship looks at his application, what he's done, it's the most perfunctory way to try and explain anything. Kindly have a look at it, my lord. Page 430. I'll just show that page number. This will be volume 4.
Yes.
Page number 430. Page 430. It starts, my lord.
All these are facts.
All these are facts.
So explanation, if at all, is at paragraph 17.
That's right. And your lordship will just see what he says here.
Prior to that are the principles for allowing amendment and other things. And
14.
Yes.
14, kindly see. The applicant states that the said applicants had all along been represented before this honorable forum. However, the applicants, while preparing the witness, were advised to carry out necessary amendment as there has been sufficient statements made in the evidence. However, the formal pleadings with regard to counterclaim could not be pleaded. There is no other explanation. And 18, your lordship will see. 18 militates against paragraph 14.
Yes.
It's contrary to.
Could not have been brought at the prior stage in spite of best efforts.
But it's contrary. He says that when I was preparing the witness, I realized. And 18 says, so 14 and 18 can't go together. So apart from this 2 years, with around 20 adjournments, 3 change of lawyers, nothing explained. Nothing explained. And this is considered by the learned tribunal, my lord. If your lordship looks at paragraph 13 of the impugned order,
page.
Lord, it starts at page 30.
First volume.
First volume, my lord. Page 35, kindly have a look at. In paragraph, sorry.
Yes.
Paragraph 18 of their application for amendment of statement of defense. The respondents have stated that the proposed amendment, proposed amendment could not be brought at a prior stage in spite of best efforts on the part of the respondent. Except this paragraph, no other specific averments have been made by the respondents to show that they could not approach the tribunal to amend their statement of defense in spite of due diligence before commencement of trial. I'll show you also why this statement was more so. The averments contained in paragraph 18 of the application for amendment is not at all sufficient to come to a conclusion that in spite of due diligence could not have raised the same before commencement of trial. And if your lordship looks at the grounds, Lord, with some responsibility, I'll tell your lordship, this point of 23.3 came only when they would have sat for a conference with senior Mr. Banerjee. Because if your lordship looks at the ground is that...
That is why Mr. Banerjee is
correct.
here.
Which is why I said not better Mr. Banerjee and lesser Mr. Banerjee. The ground in the 227 is the learned tribunal. The order is without reasoning because she doesn't consider any of the judgments that they had cited. And all the judgments were in Order 6, Rule 17. Conceive of a situation, my lord, if the tribunal had not adverted to these arguments that were made. That would have been the first ground in 227 that we had not even looked at 23.3. How did she look at 23.3? We had argued on 617. So there is, firstly, my lord, there is a delay. You're coming after 2 years. Second, there is no explanation at all. Thirdly, my lord, if your lordship looks at, oh sorry, your tamata. If your lordship looks at 23.3, the language is the language at 20.
Having regard to the delay in making it.
Just 2 words before that, Manoj. Unless the arbitral tribunal considers it inappropriate, having regard to the delay in making it. Manoj, this consideration is paragraph 13 and 19. Now the issue is when this consideration is there, good or bad. Once this consideration is there and this forms a part and is in the reference, whether under 227 that consideration can be assailed, or does it have to wait and be taken up only in 34? And I'll tell you, Lordship, if your Lordship looks at paragraph 19 once more of the impugned judgment, kindly have a look at how she considers the aspect of delay. Principle of law on the question of amendment of pleadings after commencement of trial has been well settled, because they cited 12 judgments, 18 judgments on this, while considering the prayer for amendment after consideration tribunal. Tribunal has to scrutinize strictly to ensure fairness and prevent party to cause delay in the proceedings or to prevent the party from introducing completely new issues at a belated stage. Present application is not based on any subsequent event or incident which took place after the commencement of the trial. Respondents are well aware of all the relevant facts and they have come to introduce the same after the commencement of the trial. More so, it cannot be denied that the main object of an arbitration proceeding is to provide speedy disposal of the dispute between the parties within the time prescribed by the statute. This sentiment is echoed in all these judgments which consider the intervention of a court under Article 227. May I start with one? I'll show 2 more after this. If your Lordship kindly consider. Just give me 1 minute. 2020, volume 15, Supreme Court cases 706. Here, acte copy. Well, this is a case where a 16 application was filed. A section 16 application was filed before the tribunal. 16 got rejected. They came up before a 227 court.
Yes.
Court holds that what is not appealable under 37, it was the intendment of the legislature to make it assailable under 34. So unless you can show that this is without subject matter jurisdiction, at every stage you will not come up under 227. This, instead of relying on what I say, your Lordship will just have a look at paragraph 14 onwards. I'll show 2 more on this. 14 is what had fallen from your Lordship when we opened the case. What is important to note, just above that paragraph 12, I'm sorry, my lord, your Lordship will see section 5 is quoted.
Yes.
Extent of judicial intervention.
Yes.
Notwithstanding anything contained in any other law for the time being in force, in matters governed by this part, which is part 1, no judicial authority shall intervene except where so provided in this part. Well, this being a sub-constitutional legislation, is no one case that it takes away 227. But this court in this judgment looks at 5 to interpret when to go to 227. That is what my endeavor is. 14. What is also important to note is that section 29A of the Act, which was inserted by the Act of Amendment Act 2016, a time limit was made within which the arbitral awards must be made, namely 12 months from the day the arbitral tribunal enters upon the reference. Also, it is important to note that even so far as section 34 applications are concerned, section 34(6) added by the same amendments state that these applications are to be disposed of expeditiously and in any event within a period of 1 year from the date on which the notice referred to in subsection 5 is served upon the parties. Well, this your lordship has just opined, this the tribunal also considered that it's a time-bound mechanism. 15, kindly see. Given the aforesaid statutory provision and given the fact that the 1996 Act repealed 3 previous enactments in order that there is a speedy disposal of all matters covered by it, it is clear that the statutory policy of the Act is that not only a time limit set down for disposal of arbitral proceedings themselves, but time limits have also been set down for 34 reference to be decided. Equally, in so and so, this court has also imposed the self-same limitation on first appeal under section 37, so that there is a timely resolution of all matters covered by arbitration awards. Most significant of all is the non-obstante clause contained in section 5, which says that notwithstanding anything contained in any other law in matters that arise under part 1 of the Arbitration Act, no judicial authority shall intervene except where so provided in this Act. Section 37 grants a constricted right of first appeal against certain judgments and orders and no others. Further, the statutory mandate also provides for one bite at the cherry and interdicts a second appeal.
Yes.
This being the case, there is no doubt whatsoever that if petitions were to be filed under 226 or 227, well, paragraph 17, this is of some importance, I'll just place that. This being the case, there is no doubt whatsoever
that in paragraph 17,
that if petitions were to be filed under 226, 227,
Banerjee, in the context of section 37, subsection 2, which bars the second appeal.
Correct.
So the question would be, if its second appeal is barred, whether 227 will lie without challenging that.
17 answers that, saying that what is appealable is provided for in the Act. So what is the legislative
appeal is also barred. So another challenge in the form of 227
will not lie.
Will not lie.
Will not lie because
it is purely on 37.2.
Not even otherwise. 17 kindly sees. So 16, 34, 37 are considered.
Yes.
On the ground that what the legislature wanted judicial intervention is made appealable. So where there is no recourse otherwise, then you wait till 34. You don't come under 227. If your lordship looks at 17,
yes,
this appeal, this being the case, there is no doubt whatsoever that if petitions were to be filed under 226 or 227 of the Constitution against orders passed in appeals under 37, the entire arbitral process would be derailed and would not come to fruition for many years. At the same time, we cannot forget that 227 is a constitutional provision which remains untouched by non-obstante clause of section 5 of the Act. In these circumstances, what is important to note, this your lordship will kindly mark,
yes,
that though petitions can be filed under 227 against judgments allowing or dismissing first appeal under 37 of the Act, yet the High Court would be extremely circumspect in interfering with the same, taking into account this part, that the statutory policy as adumbrated by us here and above, so that interference is restricted to orders that are passed patently lacking in inherent jurisdiction.
Scope is very limited. So 227, 226 powers cannot be taken away. So that's there. So interference only in very limited cases.
Yes, taking
inherent jurisdiction.
That's right. Taking cue from what had fallen from this bench, that everything is time bound. For everything, if I keep coming here, the statute only allows one bite at the cherry. So where you're not allowed a bite at the cherry, that's also the legislative intent. So to bypass that legislative intent and come under 227 only when there is inherent lack of jurisdiction. Well, this your lordship will also consider.
Yes.
And a better situation today. I can come back tomorrow.
You can proceed, no difficulty. Yes.
Tomorrow, my lord, I have the 4 o'clock.
Yes, you can proceed.
Oh, I can proceed. Yes. Itai. Lord, kindly, this judgment itself.
Oh, this judgment you are relying upon. Yes. Which paragraph?
Paragraph 19, SBB Patel is considered, my lord.
Yes.
19, if your lordship turns over to 717.
717, yes.
46 left.
Yes.
Yes. The object of minimizing judicial intervention while the matter is in the process of being arbitrated upon will certainly be defeated if the High Court could be approached under Article 227 or under Article 226 of the Constitution against every order made by the arbitral tribunal. Therefore, it is necessary to indicate that once the arbitration has commenced in the arbitral tribunal, parties have to wait until the award is pronounced, unless, of course, a right of appeal is available to them under 37 of the Act at an earlier stage. So this also,
Interlocutory orders are applicable under 37, you can go there.
That's right.
Otherwise, you have to wait till the...
That's right, Manoj. So that is 46. So can't, if you've suffered this, then you take this as a ground of award. And that is the that is what is your lordships have held. Manoj, one more decision your lordship will allow me to cite. This is 2025 SCC online, SC page 22. Manoj, here also, right,
SC page
22. Manoj, I'll give a copy, Manoj.
Yes.
Here also factually, if your lordship see, cross-examination was going on of the witness. They asked for an adjournment. The adjournment was disallowed by the tribunal. They filed a 227. High Court interfered. That interference Supreme Court deals with, if your lordship looks at paragraphs 12 to 16. The first principle that governs conduct of arbitral proceedings under Chapter 5 of the Act is the obligation of equal treatment of parties. Under Section 18 of the Act, it is the statutory duty of the arbitral tribunal to ensure that parties are treated with equality and each party is given full opportunity to present its case. At the same time, yet, there is another statutory obligation which is imposed on the judicial authorities. That is the statutory incorporation of judicial restraint in interfering with matters governed under Part 1 of the Act relating to arbitration agreement, composition and jurisdiction of arbitral tribunal, coupled with the conduct of the proceedings and making, challenge and enforcement of the award. This objection of restraint on the judicial authority is overriding and notwithstanding anything contained in any other law for the time being in force. Having looked into the matter, we are of the opinion that the arbitral tribunal seems to have given full opportunity to all parties, which is amply evident from the record. On the other hand, the unrestrained cross-examination of RW1 by the respondent has already exceeded 12 hours, but the respondent claimant does not seem to be satisfied with it. In any event of the matter, when the arbitral tribunal by its orator 9th October...
Paragraph 16 is the ultimate conclusion.
Paragraph 16 is, yes, Manoj. That's the
cross-examination valuable right. That was the finding of the High Court. It says no. They had a cross-examination of 20 hours.
Yes, you had your chance. Unless you show perversity.
Adequate opportunity of
That's right, Manoj.
No further opportunity is necessary.
Yes, if your lordship looks at paragraph 15 once before that.
Yes. Yes, completely perverse.
Completely, yes. Completely perverse. And it refers to condition 6 to 10 of the previous judgment, which is at paragraph 14. 6, kindly see, paragraph 14, 6. High courts ought to discourage litigation which necessarily interfere with, I'm sorry, Milord.
Yes, yes.
Which necessarily interfere with the arbitral process. Excessive judicial interference in the arbitral process is not encouraged. It is prudent not to exercise jurisdiction under Articles 226 or 227.
This paragraph 6 to 10 is from 2024 SCC Online Delhi.
Well, this is
that has been quoted.
Yes.
That has been reiterated.
That has been reiterated here. Well, this is the judgment, part of the judgment that the single bench has relied on to impose 227. Court says you've imposed 227 without looking at all these conditions which were in the same judgment. So so the intendment, you're actually going beyond section 5. Unless you can show that the power was in exceptional rarity or there is bad faith, Roman 9, your lordship will see.
Yes, I've seen.
Exceptional rarity or bad faith. That is nobody's allegation here. 2023 April, your statement of defense
And
was
10 is very important.
10, my lord.
I would that dictating the arbitral tribunal should be completely avoided.
That's right. Because 2 years, this reference has gone on. April 23 statement of defense is filed. March 25, amendment is sought with that paragraph 14 and 18 contradictory annihilating pleadings. Tribunal takes note of it, saying, and not for paucity of time, I'm not placing the other minutes. If I show the other minutes,
Any other
everywhere.
decision you want to
Lord,
cite?
there's one more which just reiterates this entire thing, Lord, which is 2022, one Supreme Court cases. This, in fact, is
2022,
one Supreme Court cases, page 75.
Yes.
Lord, paragraph 12. This 2025 is a more recent judgment, so I want to show that first.
Paragraph
12. This again, section 5 is quoted.
Yes.
Because it's based on the ancestral model, part 1 is ancestral, that is there. 13. 13 is important, Milord.
Yes.
The Arbitration Act itself gives various procedures and forums to challenge the appointment of an arbitrator. The framework clearly portrays an intention to address most of the issues within the ambit of the Act itself, without there being any scope for any extra statutory mechanism to provide just and fair solutions. If your lordship looks at 17 onwards,
18 after quoting that judgment, it's the subparagraph which is.
I am grateful.
Exceptional rarity.
Exceptional rarity, bad faith.
Left remediless.
Yes. So, and this remedy, now courts have held that this is where you take it up in 34, which is why I placed, which is why I placed paragraph 46 of SBV Patel. That 226, 227, no, these are grounds which go under 34. You take it there.
Anything more?
Not really, Milan. I'll just check one more paragraph here. Again, 17 is quoted, Milord, where it's adumbrated and only patently lacking in inherent jurisdiction. Just one line above 20, your lordship will see once.
Paragraph 20.
Just one line about paragraph 20 and paragraph 20 I'll place.
Exceptional circumstances, bad faith.
Bad faith and patently lacking in inherent jurisdiction.
Yes.
Which is subject matter jurisdiction, Milord. I'm deciding a will or something that is an in rem proceeding, a criminal proceeding. Inherent jurisdiction I don't have.
Yes.
Well, these are my respectful.
Mr. Banerjee, anything in reply?
I'll take one or little, at least 10-15 minutes time I'll need.
Please conclude, otherwise another day.
But
you will be citing only on this replies to 227.
yes, I also
He has only cited on this.
I also wanted to get that Malad where it says Malad 23.3 rejection Malad is not amenable to Malad as section 34.
23.3, yes, 30.
It's not a reward.
30, no. Do you have a judgment on that?
It is not. Yes, Malad, we have Malad. I just need to. There is a judgment on that because 34 Malad is really Malad the final. About this is not a ground Malad to go and challenge Malad in 34. So either Malad I have to come here now, or Malad that right is forever lost. Unless Malad my learned friend says that yes, that will be a ground which I'm allowed to urge. At that time, a final Malad.
Because 34 is not an appeal in that sense. So, because if it is appeal, there is a distinction between appeal and 34. In any appeals, either under not 196 or any other statutory appeals, Mr. Banerjee will be finding that the appellate authority or the court has all the powers of the original court, and
yes,
interlocutory orders also can be challenged. So 34 is different. 34 is not the appeal provision.
So what I'm saying is, Malad, a rejection of an amendment
34
application.
has to be only under these grounds.
No, what I'm saying is rejection of an amendment application
So 34 is only under these grounds.
will not be below a 34 ground.
Not all interlocutory orders cannot come under 34.
No. Here, my lord, it's a question of, my lord, rejection of, my lord, my counterclaim or, my lord, my amendment, which cannot be now considered. So in that sense, my lord, it has a finality.
Yes.
The order which have come up from, my lord, is not only, my lord, merely an interlocutory order under, my lord, section 17. Because section 23 or not section 23, an amendment rejection means I am now out with that. Whatever case I wanted to make in the amendment is out.
You have to proceed without those amendments.
Without those amendments. So to that extent, my lord, it's final. To that extent, it's final. So, my lord, therefore, saying that, my lord, I can also challenge it under section 34, my lord, is not, my lord, a argument, my lord, which, my lord, will be there. We have a Delhi. Lord, Mr. Tajguru, God, my lord, I haven't looked at, my lord, this Delhi judgment, but
that is on what point?
My lord, on the question, my lord, 34 is not a
against 23(3).
Yes, yes. আমি কিন্তু দেখিনি, তুমি দেখেছো?
আমি দেখলাম, তুমি
Anyway, my lord, it's our duty, my lord, to point out, my lord, whatever আমারটাই দিয়ে দিচ্ছি ভাই।
দাঁড়াও, শুধু দেখছেন।
Yes.
Lord, last paragraph 24, I find. Lord, first paragraph says petitioners approached the court under 34 of the Arbitration and Conciliation Act, challenging the order dated 11th April passed by the Arbitration Tribunal, consisting of sole dismissing an application filed by the petitioner counterclaimant under section 23(3) of the Arbitration and Conciliation Act. And then, my lord, I find, my lord, the paragraph 24.
Paragraph 24 is against you, Mr. Banerjee.
24, my lord, it says I'm not
against you.
Section 34 is not possible.
No. Yes. It says in a way 34 after the award is pronounced.
No, it says not making any comment on the said finding of the learner, leaving it open for the petitioner to challenge.
Rejecting only on the short ground that an order
34 is. So, no, I have no remedy now.
Only a procedural order does not qualify as an interim order amenable to challenge of the.
Lord, I am only on the ground, my lord, that 34 is not maintainable.
Yes.
A 34 is not maintainable, my lord, against his order.
Once an award is passed, he'll be able to take this as a misconduct of the tribunal. That is his paragraph 24. This court is rejecting it.
Mr. Banerjee, paragraph 24, what is the meaning of first sentence of paragraph 24? What does
not making any comment?
No,
on the said finding after the learner, leaving it open for the petitioner to challenge the same after the award is pronounced.
So after the award is pronounced, has to be under section 34.
Has to be.
Yes.
Everything culminates into the.
Kindly come to the next sentence.
Thank you.
The court is rejecting the present only on the short ground that an order
dismissal an application under section 23
is only a procedural order and does not qualify as
an interim order available to challenge under 34 of the Act.
So the Delhi High Court says it's not an interim award. You cannot challenge now. After final award, 34.
So, at this stage, I cannot challenge it. Let's go step by step.
So
at this stage,
is maintainable according to this judgment.
It does not make any comment, but yes.
Not at this stage, but after.
Yes. So, at this stage, I should be also permitted. At this stage, it's not maintainable. 34 is not maintainable. So I can only come by way of either under the Arbitration Act, I cannot come. So it can only be under 227. That's the only now kindly look at my learned friends judgments under 227. All of them say.
So you wanted to cite some decisions on 227. You said that after he cites.
No, his judgment only I'll show. His judgment, he's shown all the judgments.
All right.
Tough drilling talk.
So we'll be relying on those.
Yes. We
will be distinguishing those. We will be distinguishing.
Yes. Distinguishing and relying on them. Because all of them say 227 is maintainable, but in certain cases.
Yes.
But naturally, I have also not said, I come with 227. Even when I challenge an order of any tribunal of a court below, then also it's the same. Or lower court, I can't say court.
Lower court also you cannot say, Mr. Banerjee. Now.
What is that? My lord,
Lower court also you cannot say.
trial court. But in 227, my lord, where is the question of my lord saying only trial court? And yes, trial court. So, my lord, even if you my lord come.
Now we have changed that. Initially, what we said
LCR.
was LCR. It has been made TCR.
TCR.
There's been an amendment in the rules also.
Court below should be all right. That also is not. So, Lord, what I'm saying is, Lord, even Article 227, Lord, anyway, its jurisdiction is always restricted. It is not that, Lord, every order we can come and Lord, challenge under Article.
Interference is limited.
Limited.
If you come within that scope,
correct.
Yes.
Correct. Correct. So, my lord, let us, my lord, also look at this judgment. That's exactly what it says. It doesn't say, my lord, anything to the contrary to say that 227 is not possible.
No, it says 227 under what circumstances
Yes,
it has been.
correct. That's all I'm on. That's all I'm on. My lord, we also had.
Because 226 and 227, that power cannot be taken.
Cannot be taken.
L. Chandra Kumar has laid down that. So, after that, that's the reason Section 5 says no judicial authority. It says 226, 227 cannot be taken.
In fact, my lord, this Deep Industries 2020-15 Supreme Court cases.
Deep Industries.
In paragraph 17, it seems to suggest even.
Paragraph
17
yes.
Seems to suggest even a 37. In spite of 37, 2 also you can challenge by 227.
But it says only patent lacking.
Correct. Correct. I'm only on that. Question is 227 is not.
You cannot make a second appeal.
That's right.
You cannot treat that as a second
appeal. Because obviously the scope of appeal and 227 is different. That is why, but it says 227 is also possible. From an order under second appeal also.
But when Mr. Banerjee was challenging after 37 through 27 in pleadings in effect, you will be it will be effect an appeal when you are filing an application.
But
so try to enlarge the scope.
So paragraph 17, my lord, sees the second portion.
Yes, it's the discretion which the court has.
Yes.
Everywhere
Yes.
it says.
Now, my lord,
you cannot say it's not maintainable. Whether the court will entertain that or not.
Correct.
It's within the discretion.
That's all I'm on. Because that's all I'm on. I'm not saying, my lord, here now what is
discretionary jurisdiction only.
No, now, my lord, kindly come to my lord. देखिए लाभ नहीं उड़ीसा को राखी मतलब now kindly come to मतलब the order itself. No, so before that, Malad, in the list of dates, Malad will find it's not that Malad only. I have
on facts again. If you argue, no, it will be difficult.
You have not given this earlier.
No, list of dates. What do you want to?
Malad, in the list of dates, it will show that even they have taken time. It's not that Malad, I have only Malad delayed Malad the proceeding. Here, if Malad looks at it, they had also Malad made an application Malad for
2 years twice.
No, that's not correct. Perhaps, Mr. Malad, kindly look at. April 13.
No, Mr. Banerjee, that delay is whether you have delayed or this delay speaks of the stage. At what stage you are doing, no matter whether
should be of the stage.
Yes, it's of the stage. So, at what stage you are approaching? Maybe
we are at the stage, Malad, when I have to prove my case.
He has taken 10 adjournments. You have taken 15 adjournments. It's not that
correct.
So it's a stage. Whether at this stage,
I am at the stage where I have to prove my case. At that stage, I have come and said, please allow me to amend my counter statement. It is at that stage. It is not that, Malad, I want to introduce something which is not, or rather the proceedings are really over. I'm at that stage where I have to prove a case. I am saying that, look, I don't have all these particulars. Please permit me to have all these particulars on record. You have, because end of the day, I have to prove my case. That's the defense. So he has Malad full right to go and either cross-examine, or if he wants Malad to put his witness also, that also is there. Because he would have proved this case, I would have to prove my case. So, my lord, in that context, the delay has to be looked at. I'm grateful. I'm also not on the question, my lord, that, my lord, that, my lord, I think, my lord, on those, my lord,
The tribunal also did not go to the merits of the amendment.
Only on the
If I
delay.
find, yes, that delay you have explained or it's entitled, then it has to be remanded on that issue because the merits have not been
Yes.
considered.
Only on the delay.
merits,
The tribunal did not consider it appropriate.
delay has been, again, my lord, I say it's not been considered because, my lord, the learned arbitral tribunal really proceeded on the basis that if trial has commenced, which means his evidence has been led, therefore,
So did not enter into the merits.
that's right.
So if I am
There-
with you, then for merits, it has to be.
Therefore, on that question, you have to look at it to see whether I have
That
delayed
is one thing. And what's the next date?
20th of July.
or 20th of July.
20th of July, my lord.
That, my lord, at least, my lord, I'm sure, my lord, that can be, my lord, at least, my lord, stalled and, my
His
lord, next
witness
date
is
came.
coming into the box. It was
No, but
anyway
this
there.
depends. My witness evidence is this.
That might be a difficult thing because whether amendment allowed or not, he comes in the video. If what no purpose will be served for that. Because let us assume what he will depose with or without. So now he has to proceed without. If ultimately it is with, then
Very well. By consent of the parties, we'll take an adjournment on the 20th.
so I'm not passing.
Yes.
I'm not recording anything. 20th you said.
Yes.
20th.
I think it's Sunday. my lord.
Sunday.
Heard the learned
Mr. Banerjee, there's an eviction that is underway as we speak, my lord.
But what has happened, my lord, there's,
Take your lordship kindly.
I'm so sorry.
Yes, yes.
My lord, I'm so sorry, my lord.
Late somewhere.
Arbitration.
Yes.
My lord, there's a property where, my lord, the family resides. This, my lord, owned by a company. My lord, behind the back of, my lord, that family, my lord, I'm for that, my lord, the son, my lord, the father and the other brother have done, my lord, an insolvency resolution process and, my lord, given away this company to another company. It's all, my lord, between themselves.
Fraud.
By fraud. My lord, we made an application for the purpose of recalling of that order. My lord,
Before
which
the
was- before, my lord, the National Company Law Tribunal. My lord, we have made that application. Now, my lord, it has been heard, my lord, for the last, my lord, we finished our submission, my lord, on 7th
7 July.
July. No, we made a submission long time ago. They took, my lord, about 7-8 days, my lord, to make the submission. It's been reserved, my lord, on 7th of July. Now, my lord, reserved on 7th of July.
What do you want now?
My lord, we have challenged that process because what has happened now,
Judicial members.
my lord,
Order has not been
my lord,
passed.
judicial members not there. My lord, judicial members gone on leave.
Till 18th.
And my lord, now, my lord, today, my
Mr.
lord,
Banerjee, what can be done if a
we
matter
are
has been
my lord, today, my lord, they're evicting us.
By fine.
My lord, family, my lord, residing there. My lord, I don't know how, my lord, this can happen.
That is the
And when we
evidence
show
what
it,
we prayed for.
absolute
Where is the
fraud.
item? You have
No, my lord,
filed
we
it.
are filing it, my lord. Because
Filed,
today,
it
my
will
lord, this
appear
happened.
tomorrow.
I'm grateful. I'm grateful. We just file it.
But is there any caveat? No.
No, my lord, we will not hear about it. We'll check on that. We are no caveat.
Can you serve upon them because I do not know what will. If you want, I can place it day after tomorrow.
No, my lord, kindly place it tomorrow, my lord. Kindly place it, my lord. They're still sitting there. And very unfortunate matter, my lord, but then, my lord, that's what the situation is.
Can you serve upon them in course of this day?
That's very well, my lord. We'll serve on them. We'll serve.
May I speak in 20th is the next day in the court, but I missed my chance in the morning. May I kindly hand over the slip?
What?
20th of July is the next day. My order 16 rule 6 application has been rejected. Order 16 rule 6 for production of my title deed from the registrar.
Yes.
That application has been rejected on the
Nothing will happen.
20th is the day of my evidence. May I hand over the slip for application? Kindly, my lord. Kindly text up, my lord.
Why did it not come in the morning?
No, I tried. I had a matter. I apologize. I could not. But kindly text up. 20th is the next date.
Not possible. High Court cannot proceed on the basis of the dates. I'm trying to accommodate because these 2 dates for this resolution, those fixed matters could
The
not be
lower
taken
courts
up.
are not accommodating. That is a problem. We have prayed for adjournment. They are not accommodating.
Nothing will happen. Then Mr. Banerjee's those interlocutory orders, you can challenge under section 105 first appeal also. That's the reasoning for the amendment of 115.
Great.